a motion with regard to motion to bar individuals and groups from attempting to influence potential jurors from building and surrounding grounds. Let's go ahead and take up Mr. Goff's motion first, and then we'll address the jury questions. Mr. Goff.
Thank you, Your Honor.
Your Honor, earlier this week we filed the motion before the court, the motion to bar individuals and groups attempting to influence potential jurors from the building and surrounding grounds of the Glenn County Courthouse. We've subsequently amended that motion today with additional allegations. We have attached to the motion exhibits 1 through 4. Those are aerial photographs of the area of the courthouse and pictures from different angles of the courthouse. We would move to tender those at this time into evidence.
Any objection from the state?
Your Honor, I apologize. Let me take a moment to look at these exhibits, which were just handed to me a few moments ago.
Well, those exhibits 1 through 4 were attached to the original motion. But, Your Honor, if the state has better aerial or other photos that they would like to substitute, we have no objection to that. But if the court's going to try and fashion a remedy in this case, it would be difficult to do that without having a pretty good view of the geography, with which I'm pretty confident I'm the only litigant in this case that's really familiar with.
Your Honor, the reason the state would object to any of these things is that, number one, there have been absolutely no jurors who said they've seen any of these things. There is actually no connection to any of the jurors who have come in that they have read these things, they've noticed these things. These are all things that were pulled off the internet and printed out. So at this point in time, number one, there may be an authentication problem. I get that it's pulled off the internet and printed out, so we're all going to assume that it's legitimate, but it's legitimate as far as someone else's opinion, meaning a third party out there. So for instance, this is USA Today. Not sure what USA Today has to do with this case, an article by them.
Just photographs.
At this time, I've tendered 1 through 4. Those are 4 photographs attached to the motion, which was filed either yesterday or the day before.
I don't have any problem with the photographs. Fine. I don't need a newspaper article. Is that what is being tendered in also?
At this point, I've tendered 1 through 4. I'm going to tender them one at a time.
No objection to 1 through 4 with the photos.
The photos.
All right. Your Honor,
Those are.
thank you. Exhibit number 5, referenced in the motion, is a screenshot of a video of an interviewer, I believe with MSNBC, Tiffany Cross, interviewing attorney Lee Merritt, an attorney for the Arbery family. The tag for this video is, "Will this be an all-white jury?" Adjacent to that is Lee Merritt, Esquire's Twitter referencing this, and it says, "Register to vote, show up for jury duty. Remember this phrase, I can be fair." And that goes to the issue of whether or not there's been a conscious or unconscious effort to educate or inform or influence or intimidate jurors in this case. Now, it is admissible, that Exhibit 5 is admissible for the tweet by the attorney who is in and out of the courtroom. I don't know whether he's here today. But if the state wants additional time to explore the authenticity of that tweet, I certainly couldn't be opposed to that, Your Honor. I would remind the state that their duty in this case is not simply to convict. Their duty is to seek justice. And the state has an affirmative obligation to Roddy Bryan and to other defendants in this case to ensure that they have a fair trial. In Given the close and intimate relationship between the Arbery lawyers and the state in this case, who are shuttling back and forth to who knows where in the courthouse.
Objection. First off, there's absolutely no evidence of any relationship with Lee Merritt. Lee Merritt's not sitting at this table. Lee Merritt is not employed by the Cobb County District Attorney's Office. Lee Merritt is somebody that I recognize but have never actually spoken to in a conversation. So this intimation by Mr. Goff is completely inappropriate, and we object to that.
Well, I'll add to that, Your Honor. This is the same case where the previous district attorney handling this case, Joyette Holmes, stood on these courthouse steps in front of all the media, along with the assistant.
You can lower your tone.
My apologies. Along with the U.S. attorney, or then U.S. attorney for the Southern District of Georgia, with the members of the family, and I'm pretty sure they're lawyers in the background. The suggestion that they don't even know who he is, or know, but be that as it may, they nevertheless, as the state, have a duty not simply to convict, but to seek justice. And if there's any evidence out there that would suggest that there's been any effort, conscious or unconscious, to tamper with this jury or influence these jurors, whether here on the courthouse steps this morning or in black media, the state has an obligation to pursue it, and I would humbly submit, as difficult and as big of a nuisance as it is, and certainly unwelcome when we all have so much more to do in this courtroom, I think at some point the court has a duty to explore and investigate sua sponte the extent of these efforts and the extent that they've had influencing the jurors in this case. So I am tendering, and whether the court admits it or not, or admits it for a limited purpose, and I think it's certainly admissible for a limited purpose, but I'm tendering it and I want it part of the record, because 2 years from now or 3 years from now, heaven forbid, any of these defendants were actually convicted in this case, it's going to be very difficult to go back and sift through what was going on during this trial. And I want this part of the record. Whether it's admitted or not, the court certainly has broad discretion, and the court can say it's not going to consider it, but I want it in the record.
Exactly what is it again?
Well, I've already given a copy to the parties in the case.
I'm just asking you to describe it. What are you trying to tender?
Right, it is a screenshot with Lee Merritt's, I believe it's his Instagram page in the background, with the video in the foreground to the left and his Twitter comment in the foreground to the right. Referencing, and the key phrase here is, remember this phrase, quote, "I can be fair," unquote.
From the state.
No objection from the state. The only rebuttal argument the state would have is that this has nothing to do with the state. So I am going to just not necessarily ask Mr. Goff, but just put it on the record that conflating third parties' freedom of speech rights with the state and claiming the state has some obligation to do something to violate the Constitution and those third parties' rights is inappropriate, and right now no objection to a third party's post.
It's not clear to me that the remaining defendants are joining, so anything on the tender from the defendants.
Yeah, we join you.
But it's admitted. Go ahead.
Yeah, and I would point out that we filed a motion early in this case challenging, after the passage of Marcy's law, whether there really is, and to what degree there is a separation between the state and the attorneys for the victims. And I would respectfully submit, although I haven't checked this week's advance sheets, that's kind of an undecided issue. There's a lot of unknowns there. So I think, given that context, I don't think the motion is quite as laughable as perhaps it first appeared. But I'm going to go ahead and provide the court Exhibit 5.
Where are the first four?
You're attached to the motion, Your Honor. I'm sorry.
Okay.
One moment, Your Honor. Your Honor, the next exhibit would be Exhibit 6. That is the parties, I believe, got a copy of it yesterday. It is an article from CNN. The headline to the article, echoing the content, is quote, Ahmaud Arbery's father says he is praying for the quote-unquote right jury as jury selection continues. Now, we could, of course, just call Marcus Arbery, but he is the father of the victim in this case, and that's the last thing that I would want to do.
You're tendering the
I'm tendering Exhibit 6.
No objection.
submitted.
Exhibit 7, Your Honor, and these are all referenced in the amended. I think they're referenced. They're in either the original or the amended. Exhibit 7 is a printout from the Coastal Courier, an article by Patty Leon, published October 19, 2021, in which Ms. Cooper-Jones talks about being, quote, "I am confident that my legal team will select the right jurors to do the job," unquote. We're tendering Exhibit 7.
State.
No objection.
Submitted.
And Your Honor, I'm going to go somewhat out of order, because I think it's more logical. I'm going to tender Defendant Exhibit 13, and that is an article from Black Entertainment Television website. Ahmaud Arbery's mother speaks out as murder trial begins, in which Ms. Wanda Cooper-Jones says, "There have been lots of miscommunication in the beginning on what happened that day, but I'm hopeful that we'll get the right people in the right place to make the right decision," unquote.
No objection.
Submitted.
Your Honor, we would next tender Exhibit 8, which is an article from News for Jacks, published October 18, 2021 in the evening. Bree Isom, the reporter, I believe she was one of the women outside with the media. This is an article about the town hall meeting. There is on the website embedded a video about that meeting, in which the Transformative Justice Coalition, TJC, conducted a town hall meeting Monday evening after the first day of jury selection, during which speakers dissected the lines of questioning that the lawyers made during the first day of jury selection. And although we do not have the benefit of the entire contents of that town hall meeting, it is summarized as members spoke about jury selection and questioned the lines of questioning that potential jurors were asked, like if they're involved in any social justice organizations or if they participated in Black Lives Matter marches. Speakers at this town hall, conducted by the TJC, believed the jurors should just have been asked if they could hear the case fairly and impartially. Tender Exhibit 8.
No objection.
Submitted.
Exhibit 9, Your Honor, is a printout of an article by April Ryan for, I believe it's the Griot, entitled Arbery Family Attorney Lean Merit on Jury Selection, Culture of Racism Separation Still Very Much Intact. And that will dovetail with, I'll present this one first.
That's not, I understand there's no objection.
No, there's no objection to any of these at this point. You can put them all in.
Admitted.
Your Honor, we'll just go ahead and admit 10 at this time.
Without objection, it's admitted. These are all referenced in the motion, though, right?
Yes. We do not have an exhibit for it, Your Honor, but it is referenced in one of the previously filed motions, which is the Twitter, or rather, one moment, Your Honor. It's been previously referenced, is on May 6th of 2020. One moment, Your Honor. Referring, Your Honor, to the fourth particularized Brady motion filed earlier last year in this case, paragraph 4 thereof, on May 6, 2020, in his Facebook page, Attorney S. Lee Merritt posted they wanted to get the right prosecutors involved in this case, the clear implication being that only a black prosecutor would be acceptable. On May 11, 2020, S. Lee Merritt posted on Twitter, another huge win for hashtag Justice for Ahmaud. At the family's demand, a special prosecutor, Joyette Holmes, will replace Tom Durden. About a month later, Your Honor, we get to Exhibit 11, which is USA Today fact-checking the claim that the Honorable President of the United States, Joseph R. Biden, had somehow tampered with the jury in the George Floyd case because he put out a communication that he was hoping that the jury would reach the quote-unquote right verdict. Of course, the jury was sequestered at that time in deliberations. There was no possibility of that. But yet, only a month after Mr. Merritt started tweeting about the right this and the right that, now we have the reference again to the quote-unquote right jury in a civil rights case. Exhibit 11.
It's admitted.
Your Honor, all I have, the next exhibit is referencing an interview given by Lee Merritt, apparently earlier this week, to April Ryan, the White House correspondent for the GRIO. It is referenced in the amended motion, in which he is talking very specifically about jury selection in this case while we're in this process. Or, I'm sorry, on the day we began this process.
Exhibit 12 is admitted.
And I would note, Your Honor, although law enforcement certainly has the capability of doing that, we don't have the ability to download a YouTube video. I don't have the ability to do that at this time. There's apparently a way to do it, but it requires a level of technical expertise that I do not have. And I feel like I'm missing something. But no, I don't think so. Your Honor, getting to the heart of the motion, and as reflected in the amendment, what at first looks, when we all come in the courthouse on Monday morning, like a very innocent attempt by a civil rights group to promote voting rights, turns out to be something much different and much more centrally impacting the case. Court has already reviewed Court's Exhibit 1, which is a half dozen screenshots from their Facebook page, in which they are obviously focused on this case. And indeed, they've got screenshots. They're clearly interested in educating jurors about the jury selection process. And then they're holding a town hall meeting in the evening. But when we go to their page, and any juror curiously checking out that banner in any of the 3 days that it was present out there, at least 3 days, would readily see what's going on here. It bothers me that we have an attorney who is, I believe, representing the Arbery family in their civil case in federal court, who is basically instructing for any juror that wishes to learn through black media how to bypass the jury selection process established by law that this court has labored so hard to ensure was fair to all parties. Specifically, when Lee Merritt is discussing this case with April Ryan, he explains that knowledge of the case alone is not enough to disqualify. He states the question is whether they can set aside what they know. He then states, we don't say often enough. You know what? I can set that aside. I mean, he's basically inviting jurors to just, like Dorothy, there's no place like home, there's no place like home, there's no place by home. We're indoctrinating jurors to say, I can be fair, I can be fair, I can be fair. I'm not saying it's illegal. The First Amendment is a powerful thing. But the court's obligation, paramount obligation here, is to make sure these defendants get a fair trial. And he adds there, as he has elsewhere, this phrase, we often believe by virtue of our skin color alone that we have a dog in this fight. It gets clearer when he's talking with Tiffany Fox in that interview. I've already referred the court to the Twitter comment, register to vote, show up for jury duty. Remember this phrase, I can be fair. It seems odd to most Americans what voter registration or voter suppression would have to do with this case. But Tiffany Cross thinks it's important because she points out that Governor Brian Kemp is a quote-unquote expert on voter suppression. News to me. She expresses concern about voter registration, the primary source of juror rolls, and apathy, and that we will have quote-unquote all white juries in our future if voting rights are not, I think it's affected. She asks if an all-white jury is possible, creating the fear that there's going to be an all-white jury in this case. Mr. Merritt says, unfortunately, this is possible. Then he falsely and misleadingly states that Your Honor granted well over a dozen strikes per defendant from which to strike jurors from a panel of 64, basically suggesting to Black America that the court has authorized the defendants to basically choose whatever jury they want. He repeats the phrase, we often believe by virtue of our skin color alone that we have a dog in the fight. And this exchange between the interview and Mr. Merritt very cleverly ties together voting rights and voter suppression to this case, stoking fears in the black community of an all-white jury. Your Honor, I'm not suggesting that anybody needs to be criminally prosecuted, and I'm not sure. I guess today's an important day for us. We'll go through this jury process and we'll see if there's any degree of candor left in the jurors in this case. But unless something changes from yesterday, it's going to put us in a very difficult position if it is that we're trying to seek justice for these three men. I mean, maybe, as I suggested early on, we should just take the first 12, because if we can't get candid responses out of the jurors, then we might as well flip coins in deciding who gets on the jury and who doesn't. So I will leave it to the wisdom of the court what further remedy is necessary, but at a minimum, from this day forward, we need to restrict the access to the jurors in this case. We can't necessarily restrict what they watch online, not without sequestering them, and nobody really wants to do that. We can't control or police what they're doing at home, but we can control what happens to them when they come to this courthouse. Referring, Your Honor, to Exhibit 1, what is marked in the center as the Glynn County Magistrate Court is actually not just the Glynn County Magistrate Court, it is the Glynn County Courthouse in this case. And what I'm asking the court to do, consistent with the precedents that we have cited, is to exclude, originally I was thinking just things about this case, but really given the extent to which these people are willing to go and their sophistication to influence the jurors in this case, the safer thing would be to bar all political expression around the courthouse during this trial. And the geographic area that I'm talking about starts with what is historically known as I Street. You can see it through the trees in the diagram. I Street was taken up as a street and converted into a pedestrian walkway through the courthouse area. That is about half of that central green area. And you'll notice on the part closest to the courthouse, there are lawns that are obscured by the trees where this TJC banner was displayed for several days. Your Honor, we would ask that the court prohibit activity that will influence the jurors from the historic I Street up H Street rather up to I Street. That's both the front and back, and Reynolds Street on the Reynolds Street side of the courthouse. And Your Honor, you will notice in the picture there's this big open green area in this aerial picture. That has already been set up, I believe, by the sheriff of Glynn County, who has gone to great extents to try and protect these proceedings from undue influence. There is a First Amendment protected area set up there with numerous porta potties and I believe barricades to protect for the safety of those involved. I believe some of the media are already there. That is across Reynolds Street. Now, on the back side of the courthouse, Your Honor, we also have a parking lot that some of the courthouse employees, perhaps some of the people in this case, are parking in, I don't know, but we would contend that given that the parking lot goes across I Street, that the entirety of I Street, both sidewalks, should be off limits to protest. On the last side of the courthouse, the Ellis Street side, Your Honor, under the trees is a parking lot which folks in this case are clearly parking in. But beyond that, you know, there is a church there, and the church is not government property on the I Street side between Ellis Street and Ellis Street Lane. But in front of that, the front half of that, is courthouse parking, which the jurors, along with other people, including myself, depending on how early I get here, are having to park. We believe not just the grounds of the courthouse itself, from H to I, but from Reynolds to Ellis, including the sidewalk, should be protected, but also the parking lots, all the parking lots around the courthouse as I have identified them. And again, the court could try and do a content-based restriction, but I think under the case law, the easiest and most expeditious remedy is to ban all protest or First Amendment activity in this area until the conclusion of this trial. They can go take their places at the area designated by the sheriff, and they can speak and sing to their heart's content, as they have every right to do, Your Honor. But whether people are consciously trying to interfere with the jury process, which it would appear some people are, or unconsciously doing it, perhaps not even being aware of the greater significance of the events that are happening, whether conscious or unconscious, these defendants are entitled to a fair trial either way. And with that, I will say no more. Oh, Your Honor, let me apologize. In my diligent research at 2 o'clock in the morning, I missed a tweet from Mr. Merritt. Quote, picking a jury in Glynn County is difficult. Most of, not all jurors have heard of the case. Most have developed an opinion of the case. This juror would likely be called as a witness as her job is custodian of the records. She is obviously not qualified to be on this jury. This was a really, quote unquote, bad call by the judge. You know, even though Mr. Merritt is not a member of the Georgia Bar, he is a member of some bar, and he owes every court the dignity and respect that we are all taught and trained to provide courts in this country. And again, this is the second time in less than 48 hours he's openly been critical of Your Honor, and without foundation. In both instances, he has affirmatively misled the public as to what is going on here. And this has been a pattern of disinformation from the beginning of this case. It obstructed the GBI investigation. It has obstructed the defendant's quest for justice. It is obstructing the administration of justice. With all due respect, if the court can't come up with some way to fashion a remedy here, I suspect the defendants will be back with much more dramatic requests tomorrow.
From the state.
Thank you, Judge. First off, it appears that Mr. Goff's exhibit number 2 is undated. The other exhibits all appear to be, map data from 2021. That's exhibit 1. We have exhibit 3, August 2020, and exhibit 4, October 2019, all from Google. And then we have this photo, exhibit number 2, no date or time on it. Mr. Goff asserted that he wants some sort of restrictions about what's going on around the courthouse. So all of his other exhibits are completely and utterly irrelevant to that. This is social media posts and complaints about Mr. Merritt. State's kind of befuddled as to how social media posts, which people may or may not look at, a tweet people may or may not pay any attention to, has anything to do with his request about restricting assembly outside of this courthouse. And of course, the state wants to be very, very clear. Mr. Merritt is not a member of the Cobb County District Attorney's Office. Mr. Merritt is not seated at this table, and the state has absolutely nothing to do with Mr. Merritt and does not tell him what to do, and he doesn't tell us what to do. So conflating those two things is inappropriate and not relevant here. However, I did want to point this out to the court so that the court is aware of this. Mr. Sheffield, on October 6th of 2021, went on a radio program here in Glenn County, Scott Rifen. I think it was about a 40-minute kind of talk where he basically kind of advocated the same sort of thing. And it was done not in violation of your order, but in a way to please come to court, please say these things, please be honest with us, please tell us this, please do your civic duty.
The statement was be honest with us,
Right.
not say a particular thing to get on the jury. Let's be very clear if you're going to use that broadcast. And that you were invited to come as well.
I understand that. The state declined to come. The state did not feel that it needed to tell the jurors of Glenn County what their civic duties were. But that is available on iHeartRadio with Mr. Sheffield basically putting out his position to tell the jurors what he thought they should come and do. So I wanted the court to at least be aware of what's good for the goose is good for the gander. To throw stones at one side shouldn't live in glass houses. In this case, the state really has no dog in this fight. What's going on outside this courthouse is beyond the prosecution's ability to control, because it is a constitutional right, freedom of speech and freedom of assembly. The court has placed a decorum order in place that monitors behavior, and we leave it to the discretion of the court to make the right decision. Thank you, Judge.
Final word, Mr. Goff.
Just to be clear, Your Honor, I've been on talk radio 1,000 times, but I was not a participant in that day's events. I can't speak to the content of it. All I heard was secondhand. All I knew was I got a call. Did you hear what that lawyer did? I assumed he'd been shot, but unfortunately he wasn't. But that is completely different than in substance. There is no way to get around the substance of what Lee Merritt is doing. And what troubles me, Your Honor, is this isn't something new. This isn't something of a surprise or a shock. This has been something that the prior elected district attorney in Cobb County, Joyette Holmes, and her legal team has been well aware of from the start, because I have made it all painfully clear in numerous motions that were filed. And if nowhere does she address, and this is somewhat disappointing to me, nowhere does Madam Prosecutor address her duty as an officer of this court to seek justice and not merely convict. Instead of quibbling about the authenticity of exhibits
How about this? How about the GBI take 1/zillionth of the zeal that they've devoted to going after these three men and go check out those two interviews and get copies for the state to present for the court to review so the court can make its own judgment as to how big a problem this is. Because I don't have the capability of doing that. I paid for the premium subscription on YouTube and I still can't get it. Apparently you have to buy some special program, and through a bunch of cumbersome steps you can get somebody at the GBI. If they can do 3D drones and all this other fancy technological stuff we've got in this case, they can get these two videos. And I think the court needs to look at them. And let's bear in mind, Your Honor, that's what I can find on a Monday night, at 2 o'clock in the morning. We haven't even scratched the surface of what's out there on black Twitter and in the black media. We haven't even scratched that surface. And the further they get away from the mainstream, the more free Mr. Merritt and other people feel to comment more directly and in less, what's the word for it? Less ambiguous ways about what you're trying to accomplish. We have no way of policing that. The state does, and it's their obligation to ensure justice in this case. I would ask the court to direct the district attorney's office and the GBI to go look into this and report back to the court.
All right. The motion itself. The requested relief is to bar, as I understand it, signs or demonstrations within the area that Mr. Goff has defined here in the argument. Is that correct, Mr. Goff?
It is, Your Honor.
Let's focus on the motion itself, and then I'll address some of the noise going on. The court does not find that the movement has met its burden to limit the First Amendment rights of any individuals that may come to the courthouse grounds, which is a public place. I didn't ever hear any arguments with regard to the constitutional aspects of this First Amendment rights versus what may be happening here. I will note, because a lot of things have been noted, I will note when I came in this morning I didn't see anyone. In fact, it has been relatively quiet on the courthouse steps. There have been individuals that have come over the last week or so. I have checked in with the sheriff a couple times just to make sure that we have not been having any issues that should cause the court concern. No reported arrests, no issues again, and the demonstrations were not moved to what we'll just call the First Amendment zone, which was set up due to the fact that there did not appear to be any disruption outside the courthouse. Now, as to jurors coming in, a number of jurors have been asked about these signs or demonstrations, and I have not heard yet in jury selection, which has been thorough and sifting, that these influences that are claimed have occurred. And so at this point, the court simply finds that the movement has not met its burden on the motion to bar individuals and groups attempting to influence potential jurors. As to the what's going on, I'll call this noise outside the courthouse. A lot of this, in this particular case, the lawyers have been fully aware of, and both sides have participated in some way in some of what's been pushed out through the media, through interviews, podcasts, and a variety of other means. Now, I'm not going to suggest any, I'm not going to talk about intent or what that may have been, but both sides have done that. Both sides have been involved in raising the consciousness of the public as to what the issues might be in this case. And the court has put in place a couple of orders, one regarding the decorum in and around the courthouse, and the other being the order that restrains extrajudicial statements. And I believe under the circumstances of this case, both of those orders are appropriate, necessary, and appropriately tailored for the problems. Now, the issue I do have, though, and I will say this, it's interesting when we talk about the media and what the media are pushing out, and inside the well, what I hear everybody asking the jurors is whether they agree that what the media pushes out is not the whole story and may not be accurate, and in fact may be inaccurate. And now we're saying what's out there is a problem. because of what the media is doing. It's a two-sided argument. And I will say this, though, that the media, as much time as we've spent in the last week and a half trying to coordinate with the media, there have been attempts by the media to comply with this court's requests to maintain anonymity with the jurors, to act with decorum in the court itself, in the jury assembly room, and outside. There has been general compliance with that I have been relatively happy with. And part of that has been some back and forth, particularly with regard to the court's concerns about the size of the community and the amount of publicity that's being pushed out, and how individual jurors, for example, may be identified through questions and other things. I will tell you, it troubles me significantly that any individual, separate from the lawyers in front of me here and the media, would be taking it upon themselves to create a narrative that does not comply with this court's clear wishes with regard to jury selection, identifying jurors, and using platforms to influence the public. That is a concern of mine. Now, how I'm going to deal with that, based on what's been brought to the court's attention, specifically the tweet that was just referenced, I need to think that through. Because again, with regard to the motion itself, the court's denying the motion. But my concern is, particularly with this tweet, that there are individuals out there that may be calling out specific jurors. I don't care what they have to say about me. That's not important. People are going to agree or disagree. People in this room are going to agree and disagree with the rulings of this court. That's the nature of the beast. So that's not what I'm referencing here. What I'm referencing is calling out individuals that may or may not be participating in this case in ways that attempt to influence the public and may, maybe indirectly, have an influence upon those members of the panel. I will work through that problem. But again, as to the motion itself, it's denied. Yes.
I just wanted to make sure I understood the court's direction of putting out any identifying characteristics or features of the potential juror is where I think that tweet becomes problematic. And I think that we're on the same page when that's specifically the type of identifying information that the court has already said do not disclose to the public. Is that correct?
That's what I instructed the media not to do. Yes. We also have the, I guess, well, it is a motion with regard to additional questions in voir dire. Ms. Hogue, or Mr. Hogue.
Your Honor, I take it the court did receive the email that my co-counsel sent, I believe last evening, that lays out the questions that we're interested in propounding with some law.
Let me ask this, though. They seem to be different than what we discussed yesterday, at least some of them.
I
understood the court asking us
To either get rid of some or think about them and rephrase them in ways that might be smoother, and that's what it was.
and in fact, because this
Well,
is...
I only say that because I don't think I got it last night. I got it at 6:20 this morning.
Yeah,
So we're,
It was about 11.
it's 11 and 46 seconds. It was sent last night from Laura Hogue to all the attorneys and to the court.
which address to the court?
Yeah.
Our
No,
rules.
no.
The dress that we've been using. That would be, apologies, Your Honor, and you can. Sorry. You're gonna do an auto forward now, aren't you?
And because this is
I'm just, I don't know whether it got caught. I just didn't see it 11. I got something, actually the response from the state at 6:30 this morning, so I didn't see it last night. But go ahead.
yes, and I will say, because this is such a fluid process, jury selection that is, this morning I have thought of another question that fits within the legal argument that we're making for the questions we've included in this email, and I would like to add that to the court's consideration. That additional question is this: would you be able to give fair, meaningful consideration to the defense of self-defense where the person killed was unarmed? And that's because I think it was yesterday, and we may have had another juror last week, who brought that up during voir dire to say how troubling it was to the juror that Mr. Arbery was unarmed and faced 2, possibly 3 armed men. We know that it was 2 armed men, but some thought maybe all 3 were armed. But that was a factor for a couple of jurors that could have made the juror not be able to give meaningful consideration to a self-defense claim if the one claiming self-defense is armed and the one we're claiming is the aggressor and who ultimately is killed is unarmed. And that makes sense. That's a legitimate concern a juror could have, and so we add that question to those that are included in this email.
Let me address that part of it first, since we're adding it in, and that way I won't forget about it. All right. The court has permitted the attorneys to get into whether or not the jurors, potential jurors, would consider defenses, and even specific defenses, and even gone as far as to allow questions, not just would you consider, but almost getting into going beyond just consider. Where I have stopped that is when we start getting into some more specific facts about the case and about the potential defenses. But I point out, and there's case law all over the courts. I'm just going to put it on the record at this point. Questions seeking to test prospective jurors' willingness to accept defenses or to identify jurors who are amenable to a particular defense are properly disallowed. That's Meeks v. State, 216 Georgia App, 630. It's a 1995 case, most recently cited, at least that I could find, in... Yeah, I'll tell you where it's most recently cited that I could find. It may have been cited again since this. Recently cited in Stewart v. State, 262 Georgia App, 426. Let's see. Stewart, it goes on to explain, there's often a fine line between asking potential jurors how they would decide the case and questions that merely seek to expose bias or prejudice. The scope of voir dire, of necessity, must be left to the sound discretion of the court. And goes on to explain the Court of Appeals is not going to interfere with the discretion, absent manifest abuse. Goes on to talk about questions of technical and legal nature and questions that call for prejudgment are improper in voir dire. So as to these additional questions on defenses, the court's permitting the parties to get into consideration of the defenses, fair consideration of the defenses. The court's comfortable with where we are with that, so that will be the court's ruling on those questions.
All right, my apologies. Let me make sure I'm understanding what the court is saying. This is the ruling on the questions that we've included in the email.
This is the ruling generally. The court has already permitted the parties to ask about defenses and fair consideration of the defenses,
Right.
naming the defenses. Those have been asked. What I'm saying is there are limits, and so I'm not going to rule on additional questions. What I'm going to do is, if we go beyond where we've been with these jurors, if that's the intent, then no, if there's an objection, it's going to be sustained, because I believe the court has permitted, in fact, maybe even permitted more than would otherwise be permitted given the nature of this case, because the court has been flexible given the amount of information that is pushed out there or been pushed out there. In this particular case, I've gone farther than I normally would anyway. So what I'm telling you is the line is, you can ask them those questions about whether they'd give fair consideration to defenses, but we're not going to get any further into it, and there's support here for that.
And Your Honor, we do appreciate your latitude to us because of the nature of this case. And I want to concede on behalf of the defense that the line, and I'm quoting now from Ellington, the line between permissible inquiry into prejudice, which is then defined by the Supreme Court of Georgia as follows: a juror's fixed opinion that a certain result should automatically follow from some fact, regardless of other facts or legal instructions. Okay, the line between that, which is prejudice, and impermissible questions of prejudgment, and we have gotten many objections that we're calling for prejudgment, which is defined as speculation about or commitment to the appropriate result based on hypothesized facts. And then Ellington ends that sentence by saying that that line can be hazy, and it is. It's tough, and I want to assure the court that we on the defense side are trying to stay on the prejudice side of the line and not on the prejudgment side of the line. We're honestly not interested in laying out some facts in our case and asking jurors essentially, now how would you vote on that? What we're really doing is what Ellington itself says we're allowed to do when there are critical facts in a case that a juror might say when hearing them, that's it for me, that's all I need to hear. I don't need to hear any more evidence and any more law. And some of those facts in our case are ones that we've asked about. And the one I just indicated we'd like to add is, and again, this comes up in the course of conducting these examinations, and you begin to hear how these people are actually thinking and responding. And so it requires the adroit criminal defense lawyer to shift and change some along the way in response to what is occurring. And that's the nature of trial work. You have to be able to do that. So what concerns me, and I'm asking the court to make sure I am following Your Honor on this, is it sounds like we're being told that whatever we began the jury selection process with last Monday, October the 18th, those questions are the questions that now set the parameters of what we are allowed to ask. And I think I'm hearing the court say, and again, forgive me if I misheard, that if we go beyond that or ask a new question and it draws an objection, it will be sustained. I think I heard the court say. So if I was to ask this question today, which,
How could I, that doesn't make any sense to me.
well, again, I might have misheard.
Let me talk. If you ask a question and there's an objection made, I'll rule on the objection at the time. What I've said is that it's pretty clear what the parameters are here. I'm permitting questions about whether or not that the potential juror would consider defenses. Now, that's even a little bit further than some courts have said is okay. What you're suggesting is that additional inquiry needs to then occur. And what I'm telling you is that is potentially objectionable. Under the circumstances with that juror, if an objection is made, I will rule upon it, but I'm giving you what the court's position is right now. So, I mean, if you want to go ahead and debate it with any potential juror, you make your record, but I'm telling you right now that the question that you proposed as additional questioning, for additional questioning, may be objectionable. And the court's told you where I'm getting that authority from, because I think it may go a little bit too far in this particular case.
And you're referring to the questions that we've included in this email, plus the one I just added?
No, I simply said you brought one that's not even put in the email that you wanted to add in today. That's what I'm talking about. You started talking about the defenses and consideration of defenses and how you wanted to get into additional questioning on defenses. And what I did is I stopped you right there and said, okay, on that particular issue, let me just tell you where I am with the law, and we can just move on. And we can get back to what is actually before what was presented to the court last night.
Okay, what's in the email?
Correct.
Perhaps it would be economical to find out which of these questions in the email the state opposes or objects to, and then which one the court takes the position are not allowable no matter what the state says. That could save a little time.
It might streamline the process.
Yeah, I'm interested in that. And I know we're already looking at another 8 o'clock at night or later. So may I cede the podium to the state and let them say which parts of this they object to?
I have no problem with that.
And then I can come back up and address the ones they have objected to. And if they haven't objected to any of them, and maybe they'll object to all of them, then we have a better idea where we're going.
Ms. Domkowski.
Thank you, Judge. Regarding number one, I don't think there's an issue here. The defense has been asking these questions and the state has not been objecting. I know at least 3 or 4 witnesses or jurors yesterday were asked, what do you know about Mr. Arbery? State did not object to that question. I'm not sure what the complaint is, and I don't want to call it a complaint here, but I believe that all of us here are asking these jurors, what do you believe you know the facts to be about this case? What do you know about Travis McMichael? What do you know about Greg McMichael? What do you know about Mr. Bryan? What do you know about Mr. Arbery? And then, the question of how did that information impact your opinions, we're all asking them, do you have an opinion? The real question, of course, for the law is that opinion so fixed that you can't put it aside and base your verdict on the evidence that you hear between these 4 walls? So I think we're already asking all of these questions, so I'm not sure that that's an issue. With regard to number 2, you have supported the call for justice for Ahmaud. What are you calling for? The issue yesterday was we did have a potential juror who had said that they supported justice for Ahmaud. So asking that juror who has put that out there in their social media or even in their questionnaire, that's an appropriate question to ask them about what it is that they were calling for, what were they thinking about there. The state's objection yesterday was more towards a juror who had never put that out there, and the state just objects to the idea of planting the seed, suggesting things to jurors, getting them to talk about it simply to then be able to go, oh, well, we're going to strike them for cause because of their opinion about something that they never even said or brought up in the first place, but was suggested to them by the defense. So if a juror does say, I've supported the call for justice for Ahmaud, well, what are you calling for? What does that mean to you? The state is not going to object to that. We would object if it's asked of any jurors who have never said that or have never put that position out there. Moving on to the next question. The state objects to the question of, assume you have considered the evidence and the law at trial and were convinced that the defendants were not guilty. What pressure could keep you from voting not guilty, even if you thought it was what the evidence demanded? Given that pressure, would you agree that you are not a fair and impartial juror? This is the hypothetical that is not allowed. I believe I emailed the defense and the court this morning, both Ellington as well as Edenfield. In addition, I'm sure the court's aware, and I apologize, I handed the defense a copy of Willis. I have another copy, if I may approach.
Yes.
Of Willis. I've marked it for the defense and for the court. Willis, as the court is aware, came out in 2018. And What we have from Ellington on page 13, of course, is Uniform Superior Court Rules on voir dire. It's 10.1. Hypothetical questions are discouraged, but may be allowed in the discretion of the court. It is improper to ask how a juror would act in certain contingencies. That's exactly what this question is. If this, then what about this, what about that? And it's improper under the Superior Court rules to ask this question. It's also improper on a certain hypothetical state of facts. No question shall be framed so as to require a response from a juror which might amount to a prejudgment of the action. And Judge, it appears that what the defense is truly trying to get at here is the question they are already actually allowed to ask. Here's your general questions. It is actually the last question. Are you concerned about your safety, reputation, or your livelihood if you were to be a juror on this case? The court allowed that question. That question really goes to, is there some pressure that you're going to feel to render a certain verdict? And I guess what the defense is trying to get at is, are you, I hate to phrase it this way, but asking the juror, are you so weak that you can't hold to your own opinions and you're going to let some outside force, not the other jurors, not the evidence in the case, but some outside family, professional, societal force cause you to render a verdict you don't believe in? And that is basically what they're asking here on 29. Are you concerned about your safety, reputation, or your livelihood if you were to be a juror in this case? And the follow-up questions have been all about the pressure. The defense has repeatedly asked, have you talked with your husband or your wife about this case? Have you talked with your siblings about this case? Have you talked with your children about this case? Have you talked with your friends and neighbors about this case? They've asked what those people's opinions are, and then they've asked, have those opinions affected your opinion? So they have gone well down that rabbit hole to determine if that juror has been influenced by family, friends, workplace people with their opinions, and they've been able to ask all of those questions. So this question, though, the state would object to because it is in violation of the Uniform Superior Court Rules 10.1 and Ellington. In addition, we find it also kind of goes with the Willis case on page 20, and I'm citing for the record to 304 Georgia 686 Willis versus the state from 2018. And there, the court said, we find no abuse of discretion in the trial court's then forbidding sua sponte follow-up questions seeking to have a juror specify in which direction such a juror would be leaning, because the defense was entitled to only ask questions designed to reveal the prospective juror's general view on the critical fact, and in that case it was of a child murder victim, and whether that view on that critical fact, a child murder victim, was so strong that it would substantially impair the juror in considering all three sentencing options. So obviously this was a death penalty case. The court went on to say, we further find no reversible error in the trial court's later forbidding a repetitive question about the juror's ability to consider all three sentencing options. So Willis basically kind of reins in Ellington a little bit by saying, you can't ask about the direction. You can't ask, well, if you thought he was not guilty, what pressure outside would there be on you to come back this way? That's not allowed under Willis. To go ahead and talk about a critical fact, and they have talked about a critical fact. We've all been talking about the defenses of self-defense and citizen's arrest, and would the jurors be willing to consider those defenses? So we ask that that not be allowed. Then the defense also asked for a question, if you were on trial in this case, would you want a juror who held your current opinions and your life experiences? Why or why not? The only support that the defense has for that particular case they provided was the Irwin versus Dowd case from 1961. So this is a death penalty case, and the jury was not appropriately vetted in that case. And in addition, this is dicta. This part right here is the court going through, here are all of the reasons you all did this really, really wrong in 1961. And the only line that the defendants cite to is the fact that while going through everything they did wrong, they also found this part wrong, which was a number of the jurors admitted that if they were in the accused's place in the dock and he was in theirs on the jury with their opinions, they would not want him on a jury. Notice the subtle difference here. A number admitted if they were in the accused's place, and I'll just pick Greg McMichael. If you were in Greg McMichael's place and Greg McMichael was on this jury holding your opinions, would they want Greg McMichael on the jury? That's actually what the question was asked in this case. So that's very, very different from what they're asking here. In addition, they're asking about who held your current opinions. The state has a problem with the current opinions because the current opinions are based on the news media, which we've all agreed is wrong, is incomplete and is not the evidence between these four walls. So asking a juror, well, can you be fair and impartial based on your current opinions? Well, we've all been asking those questions. So the current opinions, which they've often said they can set aside and which are not based on the evidence within these four walls but on media, isn't really the way to ask that question. And then lived your life experiences. I believe this came up with, I know at least one, maybe two of our older African-American jurors who did indicate that they, throughout their lives, had seen some manner of discrimination, either by law enforcement, the criminal justice system, and some irregularity there. And so is this going to be based on the life experiences? Are they going to ask this of every juror, or is this specifically tailored to African-American jurors who have responded to the questions about their life experiences and any discrimination that they've seen? So we find this question to not be probative and not getting where the defense wants to go, which I believe would be, no, I can't be a fair and impartial juror, I wouldn't want me on the jury, or yes, I can be a fair and impartial juror, I want myself on the jury. But if they don't answer with either one of those particular answers, we end up down a rabbit hole, once again, of please defend your answer, please explain it to us, let's psychoanalyze your emotions around it, and the state, of course, would object to going down that particular rabbit hole. We've already covered number 3, which you have denied. And then, Judge, with regard to the question of are you aware of any impact that this case has had on Georgia law? There was a motion in limine that the defense agreed with, which we weren't going to go into the fact that this case resulted in some changes to Georgia law. Unless someone's a lawyer, and I'm not sure if you pulled a random lawyer off the street anywhere in the state of Georgia, they'd be able to tell you specifically what laws changed, even though they're lawyers, to ask these jurors about how the laws have changed. While some of them may know about it, what's the next question? Are you aware of any impact that this case has had on Georgia law? Yes, I'm aware. And then you're going to, well, what is that? What do you think the law is? Tell us all about that, as opposed to, can you put that impact aside and follow the law that Judge Walmsley's going to give you, which is what the next question should be, if they are even aware. The state objects to this because, of course, we've had a motion in limine to keep this out, and if jurors are now informed in this, basically, venue of, hey, the law changed, because I'm assuming this would be a general question, they would raise their card. Now we've told all 20 jurors, hey, this case resulted in the law changing. And
to be clear, I don't want to interrupt you, so we're on the same page. This is structured as additional individual questions, not general panel questions. None of them for the panel.
And we're not changing that.
well, my question then is, how would this come up in individual voir dire then? It would be asked of everyone individually, are you aware of any impact that this case has had on Georgia law? Once again, we're bringing it to the attention of every single one of the 20 jurors that this case has had an impact on Georgia law. The next question, if this is allowed, would be, can you follow the law that the judge gives you? Because at that point, the only distinction there is, it may have changed, but we're going to give you the law and you have to follow the law. So to bring this to their attention, we think is inappropriate, and we ask that you go ahead and not allow that particular question. I do understand that if a juror brings it up, a juror could sua sponte be talking about their opinions, and if they bring up the fact that they know the law has changed, there may be an appropriate avenue of inquiry, but the state would object to going deep into it, like, what do you know, what do you think? Because in reality, these jurors are the finders of fact. Okay? They are going to be instructed on the law, and they have taken an oath to follow the law that you're going to give them, and you're going to give them a jury instruction that tells them to apply the law that you give them, Judge, to the facts as they find them to be. So it's really irrelevant that the law has changed. It's irrelevant that they know the law has changed or that there have been some changes. What's important is, are they going to follow the law that you're going to give them in regard to this case? We ask that you go ahead and not allow that particular question. Thank you, Judge.
Thank you.
And I didn't catch the state's response to the first set of questions. Those were okay?
I think the argument was that there are other questions that are asked and permitted that cover that questioning. And I don't mean to speak for the state, but that's what I understood from the argument.
Correct, Judge.
So the content is fine. We've been asking it in other ways, is what I'm hearing. Content, the subject of this first set of questions, asking jurors what they did hear or read about the case, what they did read or hear about Travis, Greg, we could add Roddy Bryan, or Ahmaud Arbery, and then how has that information that you read or heard impacted the opinions you have about what happened on February 23, 2020?
The whole entire point of the questionnaire was to get that question, and we have that answer. That answer is written out in a questionnaire that the defense wanted and advocated for and got. So repeatedly going up and then asking even more questions when they've gotten the answer in writing from the juror. Once again, we're in that area.
That's what I understood the state's argument to be.
Okay, so the objection to it is that it's already being asked in the questionnaire. It's already been covered. But we're talking about
You have a
following it.
wonderful ability to restate things the way you wish to. I just heard the state's argument. You heard the state's argument. If you'd like to respond to it, you're welcome to.
Well, the best response to any argument is after you understand it, after you know what the argument is. And so when I restate a thing, I'm not trying to say what I wish I heard. I'm trying to say what I think I heard and ask, am I correct? And then I can
I
respond.
can't speak for the state. It's their argument. I'm listening.
Well, if the court's ruling on their argument, then I presume the court understands it and perhaps can help me out by
I'll go
telling.
ahead and rule on the motion. Go ahead and state your argument.
Well, the motion itself sets out why we want to follow up on question 2 from the questionnaire in this way. Question 2 asks, what do you believe the facts of this case to be? And it doesn't go into what else they heard or read and where they got this information, and then how their sources might impact their opinions or beliefs about the facts of the case. So that's the argument for that first set of questions. Moving on to the second question, again, I'm restating what I think I heard to make sure I understand correctly, that the state has no objection to question 2 so long as the juror has raised the issue by indicating they have participated in a Justice for Ahmaud event or have expressed that in some social media posting or in any other way, even in the questionnaire itself if they happen to say it. Or if we learn about it because they've given us their social media sites and we've looked at those and we see that they have liked, posted, forwarded, retweeted, or what have you, a Justice for Ahmaud or some similar sentiment. This question is merely designed just to ask, well, what is it that you mean by calling for Justice for Ahmaud? So I take it that that question is not objectionable to the state, and therefore we ask the court to allow us to ask it and follow up on it. The next set of questions, it's still under 2. I've written in my notes I numbered it 3, but I shouldn't because there is a number 3 later. But it's different. It's the one concerning the pressure a juror might feel that would keep them from voting not guilty, even if they thought that was the proper verdict. I don't think anyone here would deny the possibility that a juror would feel pressure from any number of sources, from family members to the community at large or any other specific person they've encountered, to convict the defendants, even if they've heard the entire case and are deliberating and thinking, possibly, I'd like to acquit, but I don't want my city to burn. I don't want there to be business closures, and I don't want my own personal life to be impacted in some negative way. And there have been many jurors who've expressed that kind of concern to us. So this is just a way to follow up on that. And it's not asking, I think the state argued just now that it's asking them to act in a certain way. The word act was used. There's no action here being asked, no prejudgment being sought. It's asking what is resting on your mind, pressure, that could keep you from rendering a verdict you think speaks the truth, and yet you abandon it and speak falsely because of the overwhelming pressure you might be under to save your own business and your home and your city. That's all that question gets to. The last one on the bottom of the page, I don't have any further comment on it than what's in the motion. And now over on page 5, what we've numbered is question 3. I now want to correct my own misspeaking earlier when I said I was adding a question. I failed to look forward enough or remember that this is in here already. This is the question I indicated we wanted to add. It's just for those jurors who make a special note to refer to Ahmaud Arbery as an unarmed jogger, or say in some way, as one juror did yesterday, this is 2 armed men and 1 unarmed man, and that's what troubles the juror. And so, in fact, that juror, I think, did say it gives me difficulty in considering self-defense when you've got armed people versus unarmed people. And that's not unreasonable to wonder if a juror has that problem. And again, this is only if they make the reference to unarmed jogger, or in any way refer to the difference in power between the armed person and Ahmaud Arbery. And if they do indicate that, we simply want to be able to ask them if they are impaired, by which I mean, quoting Ellington, whether they have a prejudice, a fixed opinion that a certain result should automatically follow from some fact, regardless of other facts or legal instructions. What would that critical fact be? Ahmaud Arbery was not armed. And so we're asking them, are you unable to consider a legal defense when you learn a fact in this case? Namely, Ahmaud Arbery was not armed. The other questions, I'm not prepared to argue those. If I get Laurie to help me, that could you meaningfully consider self-defense if the defendant didn't testify? And then, are you aware of any impact this case has had on Georgia law? Those two.
Your Honor, the response that the state had with respect to the impact on Georgia law was that we would somehow be suggesting that. But the question is, has already been, several jurors have already acknowledged their understanding of the changes that have arisen out of this case. Hate crime statutes that have now been passed, that jurors have indicated they think is a great idea and that they believe was as a result of this case. So what we are asking for is the opportunity to inquire into what jurors know, since there's been so much publicity, as I've set forth in this section of the memorandum, based on the front page reports in the AJC, linking the change in the citizen's arrest statute to Ahmaud Arbery and the situation at bar. The critical thing about citizen's arrest, Your Honor, as opposed to whether a hate crime has arisen out of this case, is that the characterization for the reason for overhauling the citizen's arrest statute was so that prejudicial things do not happen. So that this, as the governor said, replacing a Civil War era law ripe for abuse. So it is important that these jurors are specifically questioned about whether they're willing to apply a law that is now defunct. And there may be jurors, you're asking jurors in some instances, to apply a law that they would never have suspected would still apply in a case once the law has changed. So to ask some jurors who feel very strongly about citizen's arrest and very favorably about the legislative changes, it's important that they know what's actually being asked of them. And that's why, and because it's such an emotionally charged issue, because it arose out of this case, I have no intention of educating anyone. I want to know what they know so they can educate us, so that you can do the job necessary to decide whether that juror can be fair and impartial.
Okay. By the way, the email did come in at 11:12, so I did receive it. I just, for some reason, at 6:25 this morning was the state's response. At that point, I started looking at it. I didn't register the earlier version. So I did, basically what I'm saying is I did get that email, so.
Thank you, Your Honor. We sent it as soon as we could finish it up.
All right, so ask these questions. Question one, which is additional factual inquiry about Greg McMichael, Travis McMichael, and Ahmaud Arbery. Yeah, the court's allowing, well, actually, first there's a questionnaire which lays out the facts that the potential jurors believe to be the facts of the case. There are questions that are being asked about negative opinions about the defendants, who may know the defendants, who may know Mr. Arbery. As far as these specific questions, all of this is covered. The defendants are being permitted a thorough and sifting questioning of each individual. We're not going to go further than what is already being permitted, and that will be the court's ruling on the first question in the email that was sent at 11:12 last night. I'm just looking at any additional notes that I have. just had some, okay. So that'll be the ruling on that. Question number 2, which gets into, let's get to it. Well, let me just be clear for the record on question 2. Have you supported the call for justice for Ahmaud? What are you calling for? There is already a general question about Black Lives Matter. I don't know if it specifically references justice for Ahmaud, but in general questioning, we can go ahead and expand that question to include justice for Ahmaud. I run with Maud. I'm trying to think of the others that have come up during jury selection. If somebody thinks of one of those additional slogans, saying tags, let me know. But I don't have any problem adding that into general questioning.
Well, Your Honor, what I think in the state read it the same way that I intended, which is if you had, they've indicated they support the call for justice for Ahmaud. And that's the only time that we would then be asking, well, what do you call for?
But I don't think that's included in the general questions. Let me take that thought one step further. Yeah, if they respond to that in the general questions, then go ahead and follow up.
Thank you.
But as far as bringing it up with every particular
Thank you.
juror, I'm not going to permit that just as a individual voir dire for every single individual. All right, then going on with question 2, there are additional thoughts. The court's not going to permit these additional questions. Assuming you're considering the evidence in the law and we're convinced the defendant's not guilty. Again, the court touched on some of that with Mr. Hogue earlier on. Let me update, because I indicated that the most recent case I found was, I think, a 2003 case. Lester v. State, I think, is also helpful. Lester v. State, which is a 2017 case, because there's also a Lester v. State that touches on jury selection, which is a 2003 case. But Lester v. State, 343 Georgia App, 618. Georgia Court of Appeals had previously held the trial court does not abuse its discretion in refusing to allow questions designed to find jurors' willingness to accept a particular defense. So that just updates that. As to question 2, I'm not going to go further. This is prejudgment as far as I'm concerned, and the court's not going to permit it. There's also this question in what is proposed as to, if you were on trial in this case, would you want a juror who held your current opinions and lived your life experiences, why or why not? I think the defense cited to Dowd. The court has read Dowd, and Dowd references a question that was asked in that case, doesn't analyze the question. It is referenced in the context of a separate legal analysis, and it's not clear that that particular question was thoroughly reviewed or vetted in any way by the court. It was acknowledged as being asked, which I guess you would presume then the court thought it was okay under those circumstances, but that was under the facts of that particular case. It being fact-specific, I don't think it, and given the way it's referenced in that case, I don't think it controls, but there's also, in the state of Georgia, I do point out Hayes v. State, 236 Georgia App 617. Hayes v. State, 236 Georgia App 617, which found, it discusses questioning the jury, and says, thus, in a classic golden rule argument, the state cannot ask a juror to put themselves in the victim's place. Conversely, we have held that any argument that asks the jurors to consider the case not objectively as fair and impartial jurors, but rather from the biased subjective standpoint of a litigant would be improper argument. Citing to Myrick versus Stephanos, 220 Georgia App 520. So there's a Georgia case that I think is much more closely related to what is being proposed. I do not think Dowd controls, and therefore that question will not be permitted. Question number 3. The court has already ruled or indicated its position when it comes to additional facts, when it comes to the defenses that are raised. And again, I've already provided guidance on that on a case-by-case basis. The court is not suggesting the defendants can ask whether or not defendants or the jurors, potential jurors, would consider certain defenses. It's when we start getting into specific facts of the case where the court has some concern and will consider objections from the state if they are made, if additional facts are inquired into. And then finally, this question of are you aware of any impact this case has had on Georgia law? The court's going to permit the following because the court's going to permit the following in general questioning. Will you follow the law that is given you by the court, even if you think the law may be or should be different? And if there's a response to that question, then you're welcome to follow up. Again, notice, will you follow the law that is given you by the court, even if you think the law may be or should be different?
Your Honor, will you allow us to insert the word citizen's arrest, the law of citizen's arrest?
I don't want to get that specific in general questioning.
Not in general questioning. Okay.
No,
So you
but
want
if there's
to
a-
add this to, I'm sorry, I didn't understand. Just want this for general
Yeah,
questions.
go ahead and add that to your general questions, and if there's a response to that in general questioning, then you can go ahead and follow
So
up on it.
I'll add that to our list.
Do you have that, Jason?
I just wrote it.
I wrote it down. Will you follow the law the court gives you, even if you
Think the law should be different.
think the law should be different?
Think the law may be or should be different.
Maybe or should maybe.
So, Your Honor, will you be asking that particular question? No? So we did ask, I believe, that question. We'll modify, it was a follow the law question. And I think it was, is there anyone here who feels that they will not be able to follow the law? We will go ahead and amend it to this at this time,
In your general question?
in our general questions.
Yeah, it does not matter to the court how it's asked, but the court would permit the question.
Okay.
I'm not sure that made sense. It does not matter to the court who asks the question, but it will be permitted.
Your Honor, if I could have just the court's ruling on the question with respect to applying the law of self-defense in a situation where someone is shot and the person who was shot was unarmed. Under Ellington, I believe the court's going to need to rule whether you believe that to be a critical fact in the case, and if so, then you decide whether or not under Ellington we can.
Where is that question?
Well, that was the question number 3, Your Honor. I'm just making sure that we have perfected the record on this issue. We're asking for that question under Ellington. For jurors who say that Ahmaud was an unarmed jogger, could you meaningfully consider self-defense if Ahmaud Arbery didn't have a weapon? And that was question number 3 on page 5 of that memorandum. And I believe that I'm stating my understanding of Ellington, the court is ruling, it has a 2-part ruling, whether you believe that to be a critical fact for analysis and whether or not the defense can use it during voir dire.
Bear with me a second. See what the question was. Well, I mean, not sure I understand what you're suggesting the court needs to do under Ellington. And Ellington gives the court broad discretion in voir dire. I think there are a number of cases, I know there are a number of cases, some of which I have cited here today, addressing vetting a potential juror on potential defenses. Actually going as far as to say that that may be improper questioning in voir dire. And what I've said now at least twice this morning is that the court is permitting questions about whether or not the potential jurors would consider defenses. But once we start getting into facts and adding additional hypotheticals even into that question, then that is objectionable. So, would you give meaningful consideration, or I have already ruled that 3 is not going to be permitted. Again, you're adding in facts to a question about a potential defense. And again, the court's already cited case law. And then again, could you meaningfully consider self-defense if the defendant didn't testify? Again, you're being permitted to ask about defenses, and the law is going to be given to the jury about the defendant's right not to testify. So, no, those questions aren't coming in, and I think the court's been very clear about that.
Yes, Your Honor, and to be clear, I'm not arguing with you about your ruling.
No, I mean,
Yeah, I believe that in order to have a clear record, the court has to decide whether you believe the fact we're asking for to be specifically inquired under Ellington to the jury is in fact a critical fact in this case. And you can find yes or no, and if it's not, then of course you don't go to the second step. But if you believe it to be a critical fact, then the question is it allowable or not?
Ellington, I think, was a death penalty case talking about a change of venue.
Yes.
Okay, this is a different set of circumstances. I'm talking about other cases which address specifically a question asked by lawyers about defenses that are to be raised. Those cases are very clear that the court has the discretion to limit that. In fact, I've said there are cases out there that indicate we're probably beyond where some courts' discretion would cut this off. So, I mean, I'll look at Ellington to see whether or not it has a specific test that this court needs to go through. I didn't read it that way, and I think it's a different animal because, again, we're talking about a change in venue in that case, in a death penalty case. But I'll take a look at it to see whether that's the case.
Yeah, I would encourage that, Your Honor, because I don't think the main point of Ellington for our purposes here is any venue discussion. It is the critical fact issue in Ellington that instructs us and is the basis for this motion. As you might recall, in Ellington, it was the critical fact of the murder of 2 small children. And Ellington was not allowed to ask jurors about it, and the case got reversed because of that. And it has now since informed many cases, not just death penalty cases, and they cite several non-death penalty cases where, for example, in child molestation cases where the critical fact can be asked because, and the test is, if a juror is not told the critical fact, they might say, I can be fair and impartial given the charge of murder. And then when they hear an opening statement, as they did in Ellington, this is the murder of 2 two-year-old twin boys, jurors then say, had I known that fact, I would have answered no. I cannot be fair and impartial. That's all I need to hear. I'm done thinking about any other evidence you might have. So in our case, we're saying, because we are hearing it from some jurors, if I hear that the deceased was unarmed, then I'm not going to be able to consider anything further.
That's fine. Just put a finer point on it. I don't think Ellington gets into prejudgment. That's what we're talking about here.
Nor are we wanting to get into prejudgment.
That's the issue for the court, is you're asking questions that in the court's opinion with regard to defenses requires prejudgment, which Ellington does not address. So that's why I've indicated. I'll take a look at Ellington to see whether or not that fits in there, but we may be talking about apples and oranges here because that's not the court's concern about a material fact, or the language is different. What the court's concern is goes back to other cases which specifically address asking potential jurors about potential defenses and prejudgment of the case. And once you get into facts associated with specific defenses that may be raised, the court has concerns about prejudgment and asking those jurors to prejudge the case. So that's where we're not on the same page. That's where I'm coming from. We don't need to debate that, but I just want to be clear. We may be, again, talking about apples and oranges there. Okay. All right. Mr. Goff.
Your Honor, just for the record, we would adopt the motion made this morning with respect to asking those questions. Well, we're not re-arguing it, but we would want to adopt that and have that as part of the record, which is, given the importance of the questions, I thought what they said probably didn't adequately cover it, so I wanted to be clear.
And Your Honor, may I mark this in some way so we can have this in the record?
Yeah, let's do that. Can you just, if you can print it and just do a notice of filing, how's
All right.
that?
Very
And
good.
just note it in the notice of filing that this is the email that was addressed, the 11:12 p.m. email addressed by the court, however you want to do that. It's probably the easiest way.
I'll take the email if it's out.
If you can make sure all of the email addresses are removed, that would be helpful. All right.
Including Ms. Burton's.
Yes. All right. Well, I thought it was lunchtime already. It is not. All right. We ready to shift over and continue on with jury selection? Yes. Okay. Let's shift over. Once the panel is seated, we'll get right to it.
485. 488.
You'll cut down this road right here and go up on the other side of that wall. You'll be able to look fishing there. There's one fishing on the seat down there. Thank you.
This road now. 495.
Thank you.
Be in the middle of this road. 496. Right here on the end. 498. Right down at that last cushion. 500.
That's 501.
475.
Seat number 5 right here, sir. Right, you good, right? Good, thank you. He's got his own.
Definitely not. Yes, sir. Real kind of Yes. Oh, yeah.
Come to order, all rise. Cook County Superior Court is now in session. I'll Judge Timothy Walmsley presiding. Please be seated.
Good morning, everybody. All right, ladies and gentlemen, I'm Judge Walmsley, and I'm the individual that has called you all down here for jury selection in the case of the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryant. I want to thank you. I want to thank you for coming down for jury selection. I know that you have been here for actually probably a couple hours or an hour and a half or two already. And just want to let you know we have not forgotten about you. I am keenly aware of the fact that you have been here, but one of the things that we do not do in Superior Court is rush through anything that we have to address. And there were some matters that we needed to address before we got to you this morning. Those matters have now been addressed, so we're really ready to get into the process of jury selection. I want to thank you for your patience on that. I want to thank you for your patience to this point. I also want to thank you for your patience as we move you through this process. The process itself, jury selection, in this particular case, moves in two stages. What's going to occur here in this room is that we're going to swear you in as a panel. I'm going to ask you a couple general questions, but then the state and the defense are going to have an opportunity to ask what we call general questions. I ask that you respond to all of the questions that are being asked to the best of your ability. Anything that you think may apply to you, make sure you respond to it. And importantly, if there's anything that you don't feel comfortable responding to in front of the group, let me know, and we'll go ahead and figure out some way to address getting that into the record in the case and make sure that you're as comfortable as possible as we move through the process. Everything that we're doing here is being taken down by the court reporter who's sitting over here to my left. So I need for you to speak up when you are responding here in this room. The acoustics are okay in this room. We can usually hear what's going on, but I do need you to speak up a little bit so that the court reporter can hear you, so that I can hear you, and so that everybody else in the room understands your responses. And also, as we're going through the questions, you're going to be referred to by the numbers on your chest. Now, we don't use names. It's easier when we go back into transcripts to figure out who was speaking by simply referring to numbers. But then also importantly in this case, and really in most cases in Superior Court, we do what we can to make sure that the jurors have some anonymity. And in this particular case, we're doing that, one, by referring to everybody by number. We're also not allowing any images of any jurors to be published or any personal information that you volunteer to be pushed out there into the general public. And the reason we're doing that is because we want you to be candid. We want to make sure that we understand your responses to questions, because what we're seeking in this case is relatively simple. We're seeking individuals who can sit on a trial jury, that can listen to the evidence, and in an unbiased, fair, and impartial way, reach a verdict. Seems like a very simple process, but it does require some inquiry, and again, we do ask for your candor. So again, what's going to happen is we're going to do questions in here. Then once that general questioning is done, there's probably going to be some follow-up with individuals. That follow-up is done in the adjoining courtroom, and we do that individually so that you're more comfortable volunteering information. What that means is that the group of you may be sitting here for a little while. And when I say a little while, based on our experience in this particular case, what that means is the day. This process is going to take a good chunk, if not all of the day. So just please be aware of that as we move through this. We are trying to move through this efficiently, but again, we don't do things quickly just for the sake of getting through matters. We're going to do this in a way that is fair and allows everybody to ask questions that are appropriate under the circumstances. So that's the process. Beyond that, we'll take some breaks. I'll make sure you know what those breaks are, and we will get into it. So the first part of this is I'm going to go ahead and swear you in as the panel, and then just ask you some general questions. So if I could please have you stand and raise your right hand. You shall give true answers to all questions as may be asked by the court or its authority, including all questions asked by the parties or their attorneys concerning your qualifications as jurors. In the case of the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryant. Please respond to court. I do or I will. Go ahead and have a seat. Ladies and gentlemen, this is the case again, the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan, who are charged, each individually and as parties concerned in the commission of a crime by the grand jury of Glynn County with the offenses of murder, felony murder in 4 counts, aggravated assault in 2 counts, false imprisonment, and criminal attempt to commit a felony. Are any members of this panel related by blood or marriage to Travis McMichael, Gregory McMichael, William R. Bryan, or Ahmaud Arbery? No responses. Have you, for any reason, formed and expressed any opinion in regard to the guilt or innocence of the accused? If you have, please raise your hand. And starting from, it's 469, 474. It's bad, there's a glare on it, so sometimes it's hard to see when you're right in front. 475, 481, 482, 485. Can't see nobody in the back there. 488.
479.
I'm sorry?
479.
Oh, I missed 479. I'm sorry, I didn't see your hand up. 479. I'm sorry.
488.
488. 489. 495. 500. 498. 500. And 501. All right, thank you, everybody. Have you any prejudice or bias resting on your mind either for or against the accused? Please raise your hand if you believe you have prejudice or bias resting on your mind either for or against the accused. Thank you. Again, I'm going to ask this in reverse. If your mind is not perfectly impartial between the state and the accused, please raise your hand. 481, 482, 485, 495, 500. All right. Thank you, ladies and gentlemen. Those are all the questions that will be posed by the court. As I indicated, the parties will have an opportunity now to ask you questions, first by the state. Is the state ready to proceed?
Yes, Judge.
Go ahead.
Good morning, everybody. Can everybody hear me okay? My name is Paul Camarillo, and along with Larissa Oliver and Linda Danakoski, we represent the state of Georgia in this case. Do any of you think that you know any of the 3 of us? Is there anyone here who does not currently reside in Glynn County? No cards? Is there anyone here under the age of 18? No cards? Is there anyone here ever been convicted of a felony and not had your rights restored? No cards? Is there anyone here that sat on the grand jury that returned this indictment in June of 2020? No cards? Is there anyone here who currently works in law enforcement and is post-certified either locally or federally? 484. there anyone here who is 70 years of age or older and does not wish to serve on this jury? 70 years and does not wish to serve on this jury. No cards. Is there anyone here who is a full-time student currently enrolled and attending classes? No cards. Is there anyone here who is a full-time caretaker of a child under 6 years of age and has no reasonable alternative means of providing for that child's care? Number 500. 500 and 510. Is there anyone here who is a full-time caretaker of someone who is disabled or an elderly person and who needs full-time care and has no reasonable alternative for care for that person? The same question, but for elderly or disabled persons. No cards. Is there anyone here who has difficulty understanding the English language? No cards. Is there anyone here who has difficulty hearing? No cards. I'm now going to ask you some questions that you may have a question of whether or not this question applies to you, and if you think it applies to you, go ahead and raise your cards because we'll have a chance to follow up and clear it up, okay? So if you're not sure, if you're on the fence of whether it applies, go ahead and raise your number and we'll follow it up later. So we believe that this trial will last from the day up until through November 19th, okay? Is there anyone here that has a non-work related conflict, like you're having some sort of surgery or some sort of tickets to a vacation that was pre-planned and you can't get out of it? Is there anything like that, a conflict that will prevent you from being on this jury? 495, 489. Anyone else? Is there anybody here that's related by blood to the current Brunswick Judicial Circuit District Attorney Keith Higgins or any of his assistant DAs? Is there anybody here that knows DA Keith Higgins? 495. Is there anybody here that's related by blood or marriage to the former District Attorney Jackie Johnson or any of her former ADAs in the Brunswick Judicial Circuit? Jackie Johnson, anybody related to her? Does anybody know her? No cards. Is there anyone here who has an opinion about last year's DA election where Jackie Johnson was defeated by Keith Higgins? Anybody have an opinion on that? 495. Does anyone here have an opinion about why the Cobb County District Attorney's Office, that's us three here from Marietta, is prosecuting this case and has been assigned this case by the Georgia Attorney General? Anybody have an opinion on that? No cards? I'm sorry. 495. Thank you, Meryl. Is there anybody here that will be unable to give the state a fair trial because we're from Cobb County and we're from Marietta? No cards? Is anybody here related by blood or marriage to the current Waycross DA George Barnhill or any of his ADAs? No cards? Does anybody know Mr. Barnhill? Does anybody know George Barnhill Jr.? He's a former Glenn County ADA, now practicing law here in Brunswick. George Barnhill Jr. Anybody related by blood or marriage to Tom Durden out of the Atlantic Judicial Circuit? Tom Durden. Does anybody know him? No cards. Does anybody know any of the defense attorneys in this case? We'll start right here with Jason Sheffield and Bob Rubin. Anybody know them, related to them? No cards. We have Laura and Frank Hogue. Anybody know or related to them? And we have Mr. Kevin Goff. Anybody related to him or know him? Does anybody know Mr. Ahmaud Arbery? And what's your number again, ma'am?
510.
510. Does anybody know Mr. Arbery's mother? I'm sorry, 467. Anybody else know Mr. Ahmaud Arbery? What about his mother, Miss Wanda Cooper Jones? 467. Does anybody know his father, Marcus Arbery Sr., or his brother, Marcus Arbery Jr.? 485. 467. And what's your number, sir?
498.
498. That's 485, 467, and 498. Does anybody know our judge, Judge Walmsley? Does anybody personally know any of the defendants? Travis McMichael, Greg McMichael, or William Bryan? Anybody know them? Does anybody know Mr. McMichael's wife, Greg McMichael's wife, Lee McMichael? 466. Does anybody know Lindsay McMichael? That's the sister of Travis. 466. Anybody know Amy Elrod? 482 and 469. Has anybody here ever served on a jury? And by that I mean going through the entire process, like we sat here, got picked for 12, and finished that trial up. 495? Anybody else? 481. 481 and 495. Were either of you the foreperson? No cards? And without telling us the verdict, were you able to reach a verdict? 495, yes?
It was dismissed before.
And 481, no. Has anyone ever served on a grand jury? 469. Has anyone looked up any court documents on the clerk's website for this case? So when you became a juror, got summoned, there were some court documents up on that website. Did anybody look up any of the documents on this case? Sorry. 481. You're right directly behind 461. 481. Did anyone here serve in the military? Anybody here serve in the military? No cards? Does anyone here have prior law enforcement training or law enforcement experience? 484. Is anybody here related to anybody in law enforcement? 488. Same question, but close friends or family. Anybody have close friends or family that's in law enforcement? 488 is related to somebody in law enforcement. Close friends and family? 484 and 488.
485 also.
And 485. 484, 488, and 485. Please raise your hand if you've ever worked in the field of social work. Anybody work in the field of social work? No cards?
479.
479. Anybody work in the field of counseling, psychology, or psychiatry, or have a background in those fields? 496. Please raise your hand if you have any work experience in the legal field or legal training. 502.
I worked for a law firm in the past, but in accounting.
Okay.
I don't know if that counts.
Did the right thing. Just raise your hand if you're not sure. 495. Please raise your hand if you have any work experience in the criminal justice system. Could be a probation officer, counselor, working in the prison system. 484. Anybody else? Is anybody here related to or has a very close friend or family that works in any district attorney's office? Anywhere? No cards? Does anyone here have any medical training? Past CPR? So other than CPR? 488? 484? 510? 489? Anybody else? Is anyone here related by blood or marriage or have a close family friend that is a criminal defense attorney? Criminal defense attorney. No cards? Does anyone here personally know a lawyer in the criminal justice field, either criminal defense attorney or prosecutor? Personally know them? No cards? Is there anybody here who has had a bad experience with law enforcement? With the police? Anybody have a bad experience? No cards? 498? 498? And 475. Anybody else? Anybody here have a good experience with law enforcement, such that it stuck out in your mind? Good experience. 502. 501. Is there anybody here who's had a bad experience with a prosecutor or a DA's office? No cards? Is there anybody here who's had a bad experience with a criminal defense attorney? Bad experience with criminal defense? No cards? Please raise your hand if you have been accused, arrested, prosecuted, or convicted of any crime, DUI or higher. So we're not talking about traffic tickets, parking tickets, anything like that, but a DUI or higher. Arrested, prosecuted, convicted. 475. 489. Doesn't matter if you're convicted, arrested, or prosecuted, or convicted. 489. 508. Anybody else? Please raise your hand if you've had a close friend or relative that's ever been accused, arrested, prosecuted, or convicted. Any of those, whether they're convicted or not. 495. I'll start over here. 466. 467. 469. 475. 482. 485.
You did say arrested, right?
Uh-huh. 479. 489. 495. 496, 498. I'm sorry, so your card is underneath your tie. 501. Thank you, sir. 502. 508. And 510. Please raise your hand if you or a close relative or a close family friend have ever been falsely accused of a crime. If you believe you've been falsely accused of a crime. Or a family member. $495. That's $495 for that question. Please raise your hand if you've ever been a victim of a violent crime against your person. So like a robbery, an assault, that sort of thing. Victim of a crime. That's $498. 469. 479. Please raise your hand if a close relative or close family friend has ever been the victim of a violent crime or crime against the person. So same question, but for a close family friend or family. 482. 479. 498. 498. Anybody else? Has anybody here ever witnessed a violent crime in progress? Witnessed a violent crime in progress? Anybody here ever take cell phone video of a crime in progress? Anybody take cell phone video of a crime in progress? No cards? Please raise your hand if you or a close family friend or family has ever been the victim of a burglary or home invasion. Burglary or home invasion. 475. 479. 482. 489. 495. 498. 501. Please raise your hand if you or a close family friend or family member has ever had a handgun, rifle, or shotgun, any kind of firearm stolen out of your car or home. Firearm stolen out of your car or home. It's got to be a close family friend, somebody that you talk to quite often. 482. 495. 496. Has anybody here ever called 911 to report a crime, like a DUI or some sort of thing like that? Anybody call 911 to report a crime? 488, 495, 498, 502. Anybody else? Has anybody here ever have to give a statement to a law enforcement officer other than for like it may be like a traffic accident or minor fender bender, but anybody given a statement to law enforcement? 488. 475. 479. If you're not sure, raise your hand. 469. 495. 498. Okay. Has anybody here ever had been a witness at a trial? Anybody ever been a witness at a trial? Like you had to raise your hand and give testimony, witness at a trial? 484. 498, 469, 501, Anybody else? Okay. Has anybody here ever taken it upon yourself to investigate a crime yourself, other than in your professional capacity? Taken it upon yourself to investigate a crime? 495. Anybody else? Please raise your hand if you know somebody else who has ever taken it upon themselves to investigate a crime. Somebody else. 495. Take a look around and tell me if you recognize any of your fellow jurors that are sitting here today. Anybody recognize anybody? It's 498. 474. 510. When y'all met at Selden Park the other day, does anybody recognize somebody from that day over at Selden Park? All right, here's some more. All right, 466. 467. 474. 475. 481. Could you slide over just one? Not 467. Stay there. 481. Thank you. 481. 485. 484. 488. 495. 489. 496. 498. 500. 502, 501, 508. Okay. I'm going to ask this in reverse. Is there anybody here who does not own a handgun or rifle, some sort of firearm? You or somebody in your home does not own a gun. 489, 495, 502, it's 498, 501, 510. Has anybody here ever had to carry a gun as part of their job? 484. Anybody else? Has anybody here ever had firearms training outside of their work? Firearms training. 481. 488. 500. Anybody else? Please raise your hand if you've lived in Glynn County for less than 5 years. Less than 5 years. 484. Okay. Anyone here live in Satilla Shores neighborhood? Anybody here live in Satilla Shores? Has anyone here ever previously lived in Satilla Shores? No cards for both questions. Is anyone here especially familiar with Satilla Shores because maybe friends or family live there or you have occasion to go there a lot? 475. Okay. Anybody here live in Royal Oaks neighborhood? The Royal Oaks neighborhood. Anyone here previously lived in Royal Oaks? Anybody here have friends or family that lived in Royal Oaks? Or familiar? 466. Does anyone here live in Fancy Bluff neighborhood? Anybody have friends or family there? 485. 467. 498. Anybody know the street Boykin Ridge? 488. 469. Anybody else? Okay. So if we decide that you're the perfect juror, is there anybody here, and you make it on the jury, have any sort of religious, moral, or ethical conviction that would prevent you from making a decision on the case? So you get back there and you decide, I'm just not going to make a decision whatsoever. I don't care what the evidence is or what we talk about, because I have a religious, moral, or ethical conviction that I cannot decide this case. Anybody fall into that category? No cards? Does anybody here have any sort of private reason why they can't pass judgment on this case? Some sort of private reason where they cannot make a decision on this case? No cards? Is there anybody here who does not belong to any sort of religious, fraternal, or social organization? So you don't go to church, you don't go to mosque, synagogue, you don't have a bowling league or book club, you just don't do any of that. 488. 484. 500. 475. 502. Anybody else? Is there anybody here who has a relative or a close family friend, or you yourself, has ever been arrested and felt like you were treated unfairly by the police or the criminal justice system? So you, a close family friend or family member, been arrested and felt that you were just treated unfair by the police or the justice system? 479. 467. 498. Please raise your hand if you, a relative or close family friend, has ever been arrested for or convicted of kidnapping or false imprisonment. Arrested for kidnapping or false imprisonment. No cards. Please raise your hand if you or a relative or close family friend has ever been arrested for shooting somebody, shooting at somebody. Nobody's been arrested for shooting anybody. Okay. That's 508. Please raise your hand if you, a relative or close family friend, has ever been arrested for murder. Arrested for murder in any way. Not necessarily a shooting, but some type of murder. 485. Is there anybody here who feels they will not be able to follow the law that the court gives you, even if you think that the law may or should be different? So the judge will give you the law, but you think, I don't agree with that, maybe it should be different. Anybody here would not be able to follow that? Everybody could follow the law? Okay. All right, no cards. Is there anybody here who wants to serve on this jury? Anybody here want to serve on this jury? 479. So now we're going to read a list of potential witnesses for the state, and please raise your hand if you feel like you know them, okay?
All right, ladies and gentlemen, my name is Linda Dunikoski. I'm going to try and read this list to you fairly quickly, but you've got to stop me because you're going to hear a name and you might think, hey, I know that person. So get our attention, wave those hands big, okay? And don't feel free to interrupt me if I've gone on to the next name and I need to back up, okay? So the first couple of people we're going to talk about are Glenn County police officers. So we've got William Duggan, Sheila Ramos, Chris Lowther, Ricky Shane Minshew, Jeffrey Brandenberry, Parker Marcy, Brad Butler, Caitlin Roberts Phillips, Roderick Noheely, Stephen Lowry, Brandon Gregory, Diana Bibby, Sherry Bashler, 482, Sherry Bashler. Now, with the Glenn County Police Department 911 call center, we have Kara Richardson or Jamie Dunwoody. 488 knows Jamie Dunwoody. All right, back to Glenn County Police. We also have Christopher Hatcher, Robert Rash. Christopher Hatcher or Robert Rash? Robert Rash, and you're 501? Thank you, sir. Then we have Officer Powers, Officer Stansberry, Officer Owens, Officer Adam Jackson, we also have with the Glenn County Sheriff's Office, Detective Stephanie Herndon Britt. Okay, so now we're going to talk about the Georgia Bureau of Investigation. Georgia Bureau of Investigation has special agents. They also have the crime lab. So we're going to do special agents first. So what we have here for special agents are Jason Seacrest, Jessica Hamilton, Lawrence Kelly, Richard Dial, Brian Smith, Garrett Morton, Amanda Barker, Jennifer Woodward. And I think I missed Glenn County Police Officer Ronald Cooper. All right, so back to our crime lab people. James Jim Gordon, Amanda Cook, Jesse Worley, Ann Kissler-Rao, Brian Leopard, Dr. Edmund Donahue. All right, so I'm going to list off now some other names of people you might know. Joe Mandela, Joseph Allen Bartlett, Subi Lawrence, Annabelle Beasley, Christy Barber, Matthew Albenzi, John Ronald Olson, who goes by Ronnie Olson, Diego Perez or his wife Brooke Perez, Mr. Larry English or his wife Amy English, Miss Kelly Parr or her father Randall Parr. You know Miss Kelly Parr? Juror 482. Daniel Alcott, his wife Christine Alcott, or his mother Judith Alcott. Kim Ballesteros. Carol Flowers, Lauren Bennett, Linda Randall, Ashley Wittenberg, Danielle Stoddard, Cynthia Drummond. Cynthia Drummond, 466.
Nope.
Oh, I'm sorry. I'm going to back up, so I'm going to do this. 466, you know Danielle Stoddard. Okay. And then we also have 469, you know Miss Cynthia Drummond. Anyone else? Great. James Trimmings, Catherine Miles, Cody Johannes, Derek Thomas, Hillary Lauren Brady Germano, 466, you know Miss Germano? Josh McGowan, Kyle Meisner, Nicole Lee Joyner, Rusty Russ Wayne Johnson. 466, you know Mr. Johnson? Right. Mr. Zach Langford, Ashley Langford, Heaven Bryan, Peyton Thompson, did I miss anyone? Miss anyone? All right, now, ladies and gentlemen, Mr. Camarillo asked you a lot of questions. Now, as you sat here, you probably thought to yourself, oh, I should have raised my hand to that question 2 times ago. So is there anything you failed to raise your card for that you want to let us know about now? So I'm going to go down the line. Yes, sir, you are 474. What did you want to raise your card to? So a hardship for 474 on a work-related business trip. Okay, thank you for letting us know about that. And 484.
Work-related this weekend, Saturday through Wednesday. I'll be out of town.
Okay, so 484, business-related hardship this weekend through Wednesday of next week.
Yes, ma'am.
Great. And then we've got 496. Yes, ma'am.
We are closing our house out of Glynn County and moving out of Glynn County on November 15th, so I don't know if that's.
Thank you for letting us know. That is something we do need to know. So we'll get back to you on the house closing on November 15th. 496. Thank you. All right, and then we've got 501. You know Zach Langford? All right, so you know Zach Langford's father. Thank you, sir. And then 502. Thank you for letting us know. We appreciate that. 502. Sure, arrested as a minor, but it was expunged. Thank you for letting us know. Anyone else miss something that they've thought of? All right. Anything else? No? Great. We'll hand you over to the defense. They'll probably have some general questions for you.
Mr. Ship.
Good morning, everyone. We have been asking a lot of questions of people similarly situated to yourselves. And it takes time. But they have been very candid with us, and I mean very candid, open, and honest with us. And we are not afraid of that. We welcome it. And so we really seek your honest opinions and thoughts and feelings about things. Do not be concerned with our feelings. So, in working with you today, it's going to take some time, but we intend to get through it as diligently as we can. Starting from the very beginning, now that you've been sitting here for a minute, I want to put a finer point on whether or not you know Travis McMichael previously with the Coast Guard or Metson Marine, if those facts help place him for you. No hands. Very good. Thanks. His father, Greg McMichael, and if you can't see, you're welcome to stand up and come around. Thank you. And lastly, Mr. Roddy Bryan.
I don't know him, and I know him through his wife or his girlfriend.
Okay. 482, there is some knowledge and association, yes. And 469, some knowledge of an association, maybe through another individual. Very good. Thank you. Now, based on everything that you may have heard in the media or in the community, what you may have seen on television, please raise your hand if you have gotten to the point where you have now a negative feeling about Travis McMichael. Just keep them up, please. I'm going to go slowly. 467, 469, 474, 475, 481, 482, 485, 488, 489. I will go slower. You can put your hand down one second. Did I call you, sir? 467? Okay. I did 485 and 489, 488, 495. Your tag happens to be backwards. Nope. Yep. You've got it in the right location, though. That's perfectly high. 500, 501. There's a reflection on yours back there in the second row. I can't read it. Yep, 508 and 510. Perfect. Thank you all. Same question for the same reasons, but for Mr. Greg McMichael. $467, $469, $474, $475, $481, $482, $485, $488, $489, $495. And it's glaring again, sir. $498, $500, $501, $508, $510. And lastly, the same question for the same reasons as it applies to Mr. Bryan. Okay, 469, 474, 475, 481, 482, 485, 488, 489, 495, 498, 500, 508, and 510. Please share with us by raising your hands if you have negative feelings about criminal defense lawyers for any reason whatsoever that you hold in your heart or mind something negative about lawyers that do what we do. No hands. Thank you. I believe we've answered the firearm question sufficiently by a show of hands that don't own any firearms. Okay. Have any of you ever decided to vote on a particular political candidate based on their platform or their policy on limiting gun rights? You've chosen a candidate because you like the platform to limit gun rights or the types of guns that may be in circulation or may be available. And that you are 479. Thank you. Please raise your hand if you're opposed to laws that allow people to carry firearms, whether exposed or concealed, to carry them anywhere, into public places, etc. Yep, 481, 488, 498, 501. Thank you. Please raise your hand if any of you participated in any of the demonstrations or marches related to the social justice movement, either before or after the shooting and incident in this case. Social justice movement, however you want to define that, if you participated in it, we'd like to understand that a little bit more. 500, our only participant. Okay? please raise your hand if you have supported in any way the Black Lives Matter movement. Now, this support can be anything. It can be financial support. It could be putting up a yard sign, putting up a bumper sticker, posting about it, reposting about it, including all of the movement about justice for Ahmaud. So if you've supported the Justice for Ahmaud, or I run with Ahmaud through bumper stickers or posting or platforming, whatever, that could include say his name, Ahmaud Arbery, as well as giving support for hate crime bill legislation. If you just raise your hand so we can see all those hands. Very good. 467, 469, 479, 482, 488, 489, 498, 500, 510. Thank you. Please indicate if you feel you have ever been denied an opportunity because of your ethnicity, your background, or your race. $485, $498, $501, $508. Please indicate if you've ever been falsely accused of doing anything based on your ethnicity or your race. $498. $498. If you agree with this statement, please raise your hand. The old Georgia state flag, the one that was flown between 1956 and 2002, is a racist symbol. Yes, 479. If you agree with this statement, please raise your hand. People of color are not treated fairly in our criminal justice system. Raise your hand if you agree. 467, 474, 475, 479, 485, 489, 495, 498, 500, 501, 508, and new on the scene, 502. Thank you. Even more focused than the criminal justice system, you agree that police in this country do not treat black and white folks equally. You don't have to have a specific experience with it, but if you feel that way locally, statewide, or nationally, you would just raise your hand. 467, 479, 485, 489, 495, 498, 500, 501, 502, 508. Did I miss you, sir? Yes, sir. I apologize. 475. If you agree with this statement, please raise your hand. Do you think that a psychologist or psychiatrist can find mental illness in just about anybody? $466, 479, 481, 488, 496, 500, 501, 502. Thank you. If you have an opinion about the time that elapsed in this case between the incident date of February 23rd, 2020, and the arrest date in May of 2020, if you have an opinion about the delay or the time lapse between incident date and arrest date, please raise your hand. Four, 6, 467, 469, 479, 481, 482, 485, 488, 489, 495, 496, 489. Sorry, it's 498. I did it backwards. Sorry. 500, 501, 508, and 510. Last question. If any of you have any medical issues ongoing or any physical, visual, hearing, whatever there may be that would cause you to lose focus or concentration during the trial, absent a morning break or lunch break or afternoon break, that you feel would impair your ability to stay focused on the trial, if you'd please indicate. We want to have your full attention at all times. 469, 498, 508. Wonderful. We look forward to speaking with you all soon. Thank you so much.
All right, thank you, ladies and
508.
gentlemen. So what we're going to do at this point is we're going to take a recess and then get everybody from over here into the courtroom and start with some individual follow-up. During the recess, I'm going to ask that you step out of this jury assembly room, and I'm going to give you some instructions. The instructions are going to apply to all of you until you are further instructed by the court. The instructions are: do not discuss this case or this process or anything having to do with this with anybody, including your fellow jurors. Do not go looking for any information about the case, meaning don't get online, don't check your news feed, don't go looking for any information on the internet or any other place that may be out there. Again, do not go looking for any information about the case. If anybody approaches you about the case, which means your fellow jurors or anybody else for that matter, please notify the court and we'll go ahead and address that. Also, during this brief recess, just grab your personal belongings. When you come back in, we're going to bring you back into this room, and again, we'll be calling individuals back into the other courtroom for some follow-up. So, with those instructions, we're going to take a short recess. I thank you for your time. I thank you for your patience, and we'll see you all in a little bit.
jurors, potential jurors from panel one. We were jointly going to ask the court the following. Could we take those 8 jurors from panel one and bring them in on Friday? Could we join to those 8 jurors 6 from today's panel? The last 6 on today's panel, making it a total of 14 for Friday. And we might need to add an additional 2, one who didn't show yesterday and another that didn't show the other day. We're trying to see if we can clean up the remaining jurors that we haven't gotten to on panel one and do it this week, because we are optimistic that by the end of this week we will have reached what we need to do our selection. We want to make sure that we wrap panel one in, along with taking 6 off the end of today, since we're at 120 and we have 16 to go. And we need to pick up 2 more. So that would give us 16 for Friday. That is our joint recommendation to the court. But we understand there's a lot of moving parts here. We wanted to bring it to your attention.
From the state?
Well, we leave it to the discretion of the court.
I thought it was a little stronger than that. I thought it was a yes, we like that idea.
Well, we do like that idea, but of course, we don't know what the court's plans are, so therefore, no, okay. I meant to say, yes, I agree with Mr. Sheffield that that might be a possibility and a way to clean that up if the court agreed, and I leave it to your discretion to decide as opposed to me trying to sell you on it.
I don't plan on changing any of the process that I've already announced, which is we've got panels of 20 coming, 8:30 every morning. The 8 that remained from Monday of last week have been placed on a, what we're calling a conflict panel. Basically anyone that had conflicts with any other dates was placed on additional panels. So they still remain in the pool, but they have already been assigned other times and been told a second time to appear. I think it would be terribly confusing to tell them a third time to appear on top of the logistics associated with addressing that through the clerk's office. I just in fact spoke with the clerk, and I know the clerk's office is working hard, diligently, and late into the evening. So instead of wearing the clerks out by changing the process again, I'm inclined to go ahead and continue the way we are. But I hear what you're saying.
I would join in their non-consent motion, I guess. Alternatively, I guess the court could just move the last 6 jurors from today to the other day with the rest, but there's just no way we're gonna get through 20 today. And,
See how we do.
I'm sorry?
Let's see how we do. I intend to proceed, and if we reach a point where it's clear that we're just not going to be able to make it through, then we won't make it through. But as you all recall, we started with 40 a day, we're down to 20, and now you're suggesting 14 and 16 on Friday. And the court has announced over and over again how we've done this logistically, and we've got members of this community that have been assigned dates and times to appear, and that's how the panels have been set up.
Thank you.
All right. So, I mean, if we end up having to take partial panels, I'm not sure where those people would go. Just so you know, if we end up doing partial panels, which I really don't want to do, but if we do, those people will probably end up getting pushed to later dates onto one of these conflict, again, conflict meaning that's just what the court's calling it, panels later on, and you won't reach them, would be my guess. All right, stay ready to proceed.
Yes, Your Honor.
Defense ready to proceed?
We are.
All right.
Judge, the panel is all back from lunch.
Okay, and we do have everybody back. So everybody is available for questioning if they wish to be And from Gregory McMichael
Yes, Your Honor, we're ready.
and Mr. Bryan.
We're ready, Your Honor.
All right, 466.
No motion from the state.
No motion from the McMichaels.
No motion for Mr. Bryan.
466 is qualified. 469.
No motion from the state.
Motion from the McMichaels.
Who's going?
All right. Motion?
Thank you, Your Honor. Juror number 469 indicated in the summary that Mr. Arbery was hunted down and killed unnecessarily. I do not feel it was because he stole or could have stole anything. His hands were empty and was jogging. Also, video was clear that Mr. Arbery was gasping for air and no one helped him, cops included. This juror was initially questioned about a conflict or hardship as a professional golf caddy, but felt that, and really didn't feel as if he had a backup plan, but of course, if he couldn't be there, they would have to accommodate.
Hang on.
Am I not over there?
Inflating 469.
Oh, I'm sorry. I'm sorry. One moment. Just conflated two different people here.
I was
Okay.
worried that my notes were woefully
Yeah,
off.
all right, now I'm with you, now we're back. 469, I did read the summary appropriately, but during the state's questioning, this juror said it was the video and that made her gasp, the video, she kept repeating. You can't make your mind forget the video and everything you've seen and heard. This juror said every single time she was asked by the state, but can you set it aside and pretend you didn't see it or don't recall it? She never said it affirmatively. She always qualified it by saying, I can honestly say that I can set aside what I've seen and heard, but with respect to the video, all she could say is, I will try. Her opinion was, I don't see it any other way than that he was killed, and that there are a couple of facts that stay with her. She can't guarantee that they wouldn't influence her. And what was critical here, Your Honor, is she has a personal connection. She was very familiar with that area in Boykin Ridge where Ahmaud Arbery lived, right across the street from Ahmaud. She watched live coverage of what looked like the pretrial hearings that she characterized as the stuff that they wanted excluded. She talked about several things that are not coming into evidence in this trial. Asked again about whether she could put those aside. She said again, I'll just do my best. This is the woman whose daughter, son-in-law lived with her, and they were very good friends with the across-the-street neighbor of Ahmaud Arbery. So she has an actual memory of having seen Ahmaud run, and in your heart and mind, you can't forget even if you want to. She reiterated that she had concerns about being fair, especially when comparing it to the notion of grand jury, when she believed she was a fair and impartial person and could put aside her opinions about cases until she heard the facts. But in this instance, she has things that she says harbor inside of me the depth of what happened. For that reason, Your Honor, we asked the court to find, as she did, in your heart and your mind, that she has concerns about being fair, and that we ask that you exclude her.
Okay, the court's, I kind of take exception to the way that's presented to the court. In my heart and mind, I understand the language, but the court has to weigh what is before the court
I'm sorry, I'm having trouble hearing you, Your Honor.
I was just commenting on, I would hope that the court similarly in their heart and mind would just take exception to that. That's not really the court's role, but I understand.
Then you've misheard me. I'm sorry. I was not speaking of your heart or your mind, Your Honor. I was inartfully saying to you, I asked you to find that she could not be fair, just as she said, and I quote her, in your heart and your mind, you can't forget even if you want to. And that's why she had concerns about being fair.
It sounded odd, that's why I commented on it. I just,
It is 6:10, so, all right, thank you.
yeah, no, and I didn't mean to call you out, and I just, as you're probably noticing, I'm a bit of a stickler for language on the record and how we present things, so.
I appreciate you doing that.
Okay. From the state.
Thank you, Judge.
I'm sorry, Mr. Bryan, and thank you, Mr. Bryan, to add
We join in the motion.
from the state.
Thank you, Judge. This juror agreed that she based her statement in her questionnaire on the news and social media, and she agreed that the news doesn't get it right all the time, does not always have the facts of the case. She said she would try, but she can't guarantee. She said repeatedly, I would certainly try. And she had no opinion, actually, about the guilt or innocence of the defendants. And then she said, I do not have all the facts in the case. I would try, but I can't guarantee it. And that, once again, that's back to, what she's talking about, what she believes the facts to be. And the problem here, Judge, is that everybody's seen the video, and they're going to see it again if they come to trial. And so when people say, well, I've seen the video, and I've made up my mind, we all know that there's going to be a lot more evidence than just that video presented at trial. And we try and encourage them to be open to that. And she said she certainly would try to be open to that. The live coverage of the pretrial hearings, she was very distracted. As we all know, it was 2 days worth of motions hearings. She said lots of kids, lots of other adults. She caught some of it, didn't catch all of it. She knew about the medical stuff, but said, I don't understand why that would be kept out. So it's obvious she didn't really understand what that evidence was. She did say, what I've seen gives me an uneasy feeling and harbors the depth of what I have seen. It just bothers me. The video bothers her. And it's a video of someone being shot and killed, so of course it's going to bother her. She indicated she would try to set that aside. Once again, the fact that Fritz across the street, and she went over there a couple of times to pick up a 2-year-old and I think it was a 6-year-old, and happened to see Mr. Arbery working out at Boykin Ridge does not disqualify her from being a juror in any way, shape, or form. That would be like disqualifying somebody because they drove down the street and were able to see the Circle K or the McDonald's where the armed robbery happened. The fact that she did not indicate on any level the same sort of emotional connection that a prior juror had indicated when Mr. Rubin was questioning that prior juror. She just indicated, yeah, I just saw him one day. I don't know him. I don't know Wanda Cooper Jones. I never went over there. I didn't say hi. But the kids, these little kids, seem to know who the guy across the street was. So there doesn't seem to be anything that would disqualify her for that. She only gets information about Black Lives Matter, and then she said, well, all lives matter. That was her opinion, but she only gets that because of the grandkids. She only seemed to wonder why it took so long, why something wasn't handled right away, and wondered if they were doing their job, meaning the police and Jackie Johnson. But there wasn't anything that indicated there was a prejudice or bias against the defendants because of that. She did describe what she recalled from watching the video, but as I've already stated, she's going to see the video probably one too many times during the trial anyways. She couldn't remember any other video, and she sometimes watched the motions hearings. Once again, she reiterated she did not know Mr. Arbery. I did not know him at all. The kids had seen him running. I saw him lifting weights from a distance that one time. She did indicate that she would try to do, when asked about the grand jury, I would try to do my best. I don't want to be biased. She indicated she had some concerns, but all that she knew about Mr. Arbery is that he was an avid runner. She did not know him. based on the totality of all of her statements and the fact that she was willing to consider the additional evidence in the case, she was willing to go ahead and consider the defenses, and that she would certainly try, we ask that you not strike her for cause.
I've got notes, but maybe they're not defined enough. I had a note that she wouldn't listen to a witness, would just blank her out. Is that this?
Cynthia Drummond, she said that about.
Cynthia Drummond is a potential state's witness, and it's someone she knew personally who had no credibility with her. So.
If we could inquire, is Cynthia Drummond still a state's witness?
No, Cynthia Drummond is not still a state's witness.
Okay. Make sure she didn't need to become our witness now.
Okay. All right, on juror 469, the state has outlined a number of the facts that I have, as has the defense. I'm not going to go through all of those again, but I will point out the ones that are material to the court. The court is going to grant the motion to strike for cause. During the state's questioning on a number of occasions, the juror said that they couldn't honestly say that I can set aside the opinions in the case, which are set forth in the questionnaire. Was asked specifically about an opinion, about her opinion, I should say. I don't see any other way that he was killed, was her statement. She did say she didn't then have an opinion on guilt or innocence, but the court has to look at the totality of the answers. She indicated that she would certainly try to consider everything put before, but couldn't guarantee she could set aside what she knew in the case, which is that much more important with this particular juror, because she did watch live coverage. I want to say watched, it was on in the background, but it was there. She did remember some of the things she heard from the motion hearings. For example, that health records came up. I must assume that those were the mental health records that were presented at a prior motion. She also remembered talking about jail calls, which again came up in the motion hearing. So although it wasn't on in the background, she did in fact have a specific memory of matters that have been addressed by this court, quite separate from evidence. Well, some of it is not at this point evidence at trial, but those particular matters were addressed more than the fact that they existed. The actual contents of those records were in fact discussed by the parties also during those hearings. She did talk about going to the house across the street. That raises a concern for the court because it does create a personal connection. That was in fact addressed during the defense questioning of the juror, and she admitted that it did make it more personal. She said she'd seen him running and saw him working out in life. Those are, at least with regard to the running part of it, I know something that's going to be discussed extensively at trial, and so those are facts that she would be bringing in, which may be material. And then she made this statement right at the end: I can't forget things that have burrowed up in there, talking about her mind. So she was very candid about the fact that it would be very difficult to set all of that aside. Based on all of that, again, the court is going to grant the motion to strike 469 for cause. $474.
State's motion to strike for cause.
No objection.
No objection.
No objection.
464 indicated a fixed opinion, struck for cause. 479.
475.
I'm sorry, I always missed that one. No, it's not the one I always missed. 475, I'm sorry.
No motion from the state.
Motion from the McMichaels.
Rejoin.
All right. Motion from the defense.
Thank you, Your Honor. This juror wrote in the questionnaire, ended it with, "The young man should not have been shot and murdered in the streets of a friendly neighborhood." When asked on the questionnaire who he's discussed the case with, He indicated almost everything that was available: friends, family members, neighbors, spouse, in-person social group, business associates, co-workers, and others. He then was questioned about his opinion. He said it was a bad set of circumstances. They cut him off and shot him in the street. He'd seen the video, he'd spoken about it with his friends. It was, as he said, the talk of the town. I've heard every opinion. Asked if he could base his opinion and reach a verdict on just what he heard in the courtroom. There was a distinct hesitation, after which he said, I like to think I could try. I like to think I could. He was asked, well, would you try? And he said, sure. So he said that he had seen, in his quote, all the videos, read news articles, looked at it on Facebook, and with respect to the video, during the state's questioning, he said, I don't know if I could set that aside. It is pretty front in my opinions. He said, he did active research on Facebook about the case, and again said, when asked, he was working very hard to be honest with the state. He would try to be able to set aside the opinions that he formed, but didn't believe he could set aside that video, which he'd seen 5 to 6 times and even watched it slowed down, which he says was pretty rough and that it was gruesome, and that he's convinced that the video pretty much tells the story. He had spoken about it with all these folks I just mentioned, had heard every other opinion that was not like his, and was not swayed by any of them. So, asked about his experiences with unfair treatment in the system, he talked about his friends of color who had shared with him that this was an experience of their lives, and helped him to understand that. And that's when he was asked about whether he believed race played a part in this case, and he said maybe. His response was, when it rains, it pours over the past year, meaning that this case is lumped in with what he called all other cases. So I pushed him on that issue, and he talked about there's been this and BLM, and this kind of pushed that along. It was a big issue in the whole social justice movement. So asked again if he could set aside the facts that he had heard. He said it's hard to uninfluence yourself on what you've heard and opinions you've formed over the year. And that is an interesting point, that these opinions have been solid in some of these jurors' minds for quite some time. You'll try, he said, but still hard to wipe my mind. He actively researched the case, and going so far as to research the law. And his conclusion was that they broke the law because in the middle of the street, when they chased him down with guns. I will try my best, but it may be hard to be impartial. I would ask the court to find that while he aspires to impartiality, that just is not a realistic assessment of his ability to be a fair and impartial juror in this case, and we move for cause.
Mr. Goff,
We join in the motion, same grounds.
from the state.
Thank you, Judge. Actually, on his questionnaire, he basically said, I don't know any of the facts. And then he said, but my opinion is, I believe that Mr. Arbery, or Ahmaud Arbery, probably should not be at the construction site without permission. But the young man should not have been shot and murdered in the streets of a friendly neighborhood. So the defense read the last sentence, but he also indicated a different side to the story, which is Mr. Arbery should not have been at the construction site without permission, and that was part of his opinion. He did indicate that he did not have an opinion as to the guilt or innocence. I don't think I know until explained to be judging. He was a bit inarticulate about that. But the state cleared that up. He said yes, he would hold the state to proving the case to him beyond a reasonable doubt. He would take the law from you. He would consider both the defenses of self-defense and citizen's arrest, and he would base his verdict solely on the evidence from this courtroom. He said he would try to set the negative feelings he had from what he saw in the video, he'd set those aside. I would like to think I could. I would try to do that. And that is all we can ask of any jurors, to try to do that. He basically said that black people and white people, criminal justice system, law enforcement, it seemed a little lopsided. But he could set those feelings aside and give both sides a fair trial. He said, yes, he could. He felt he got treated fairly during his DUI. And he said the only reason he really researched this, he said, I saw something on Facebook on the news, I did not dwell on it, but I do try and pay attention when things happen in Brunswick and Glenn County. Despite the fact that he didn't know if he could set the video aside because it was burned into his memory, once again, that's irrelevant because he's going to be shown that video repeatedly, including frame-by-frame stills during this trial. He was eventually asked, is there any reason you can't be fair and impartial in this case? And he said, no, there wasn't any reason he couldn't be fair and impartial. When asked by Ms. Hogue, what do you know? I don't know any facts. And then he said, well, I gathered some of this information from Facebook and the water cooler talk. And this is when he indicated, what sticks out to you in your mind. And once again, the defense seems to burrow in on this. What's your emotional response to all of this? Not your intellectual response. Can you put this aside and judge this case on the evidence? But what is your emotional response to seeing a video of someone being killed? We're going to strike every juror if every juror doesn't, I don't know, I want a juror that doesn't have an emotional response to watching a video of someone being killed. So that should not weigh into this. Basically, he's heard every opinion. Not everybody thinks the way I do. Some of the people he talks about this, they think that the defendant should not have even been arrested. Some of his friends think, yeah, they should be sent off to Siberia. But he said, I'm not swayed by all these opinions. We all know what we saw in the video. Whether or not it was justified, is one of the other opinions that he has considered. And he talked about his friends talking about that. He said he's going to try to listen to the instructions. Once again, hard to wipe the video from my mind, but he's going to be shown the video. He said he would try his best to start out as impartial. Well, he's supposed to start out as impartial, and our job is to go ahead and push him into a guilty verdict. And that's what we will attempt to do. At this point, the fact that he's willing to start out and do his best to be impartial, and that he's willing to consider all of the defenses and hold the state to its burden, we ask you to not dismiss this juror for cause.
All right. Again, state and the defense have gone over their facts. I'll just note generally that during the state's questioning, this comment was a don't know guilt or innocence, don't know, I hope that wasn't my language, maybe that was his phrasing, don't know guilt or innocence without the facts, would hold the state to the burden, base verdict solely on the evidence in the courtroom, did have negative feelings based on the video, but would like to think that he could set it aside, that was his language, can give both sides a fair trial. I have heard every opinion. He's one of those individuals that said that this had been the talk of the town for quite some time, so he'd heard from a lot of different people and a lot of different opinions. And in fact, based on his statements here, obviously he and his wife were even talking about this while they were filling out the form, but he can form his own opinion. He indicated to the state that there's no reason he can't be fair and impartial. Then while being questioned by Ms. Hogue, he's not swayed by other opinions. Let's see. And then to Mr. Goff, I think I can be fair and impartial. Based on that, the court's going to go ahead and deny the motion for cause. 475 will be qualified for the panel. $479.
No motion from the state.
Motion from the McMichaels.
Go ahead.
Rejoin.
Your Honor, juror number 479 indicated in response to the questionnaire, I quote, "A person's life was taken and justice needs to be prevailed." This is the juror who asked one of the parties to know that she would like to serve on this jury. She raised her hand at the beginning that she had formed and expressed an opinion, and when asked about what that opinion was, did not seem very willing to share it. This juror, aspirationally, is focused on peace for this community, which is very nice, but her goal and the question, why do you want to be on this jury, is we want to see justice done. It was asked what your opinion of justice is. She said to be fair. The state asked her, well, you've indicated that you, and of course have had on your website, your Facebook page, Justice for Ahmaud. She said, and yes, I've seen that. Was asked what that means to her, and she said if the person did what they did to him is wrong, then they need to pay for it. It won't bring him back, but it'll let people know you can't do people any kind of way, and we all have rights. Later on, Mr. Hogue was asking her about that statement and those rights, and she recited to him an unfortunate story about having been walking through neighborhoods without IDs and being in places where somebody might decide, she said, I don't have the right to walk down the sidewalk. She was asked if she had been referring to where Ahmaud Arbery was and his right to be running in Satilla Shores, and her response is, he's a human being, yes, sir. So then it all started to go kind of sideways, Your Honor. She was asked by the state if the defense presents a defense, like self-defense or citizen's arrest, will you listen and consider it? And she immediately said, I'd listen. She was asked then, would you consider it? And she agreed that she would do that. But when asked about her having raised her hands to the question whether people of color have been unfairly treated, she went into her description of this unfortunate situation with her son, and then we were able to learn a little bit more about her son, who in many ways, she said, I have a son that has a record. He was at a store washing his hands. The police came in, told him that the clerk wanted him to leave. He started to the door. They grabbed him by the shirt. They maced him. And then this horrible thing about the Glynn County Sheriff's Department and her description is that they took him to jail, kept him there for 8 days. He wrote a grievance, and the jail said, if you tear up that grievance, we'll let you call your mama. And so he did, and the son did. But she said, that kind of things happened not just here in Glynn County, it's happened in Atlanta too. And I don't know what this was responsive to, but vengeance is mine, saith the Lord. They have to pay for what they did, either here or in the hereafter. So what we then learned is that her son, while he's in his 50s now, has suffered from bipolar disease for some time and was in places that he wasn't supposed to be, and now fortunately they've been able to take care of him and medicate him. And it may be, given the facts that we know about this case, that this is a situation that might really hit home for her as well. But then when Mr. Hogue came up to begin to question her about the answer she gave to the state, she completely drew back. I don't know if she just forgot or she wasn't being candid, but she said, I never said anything about my son's situation having anything to do with race. There were black cops there and white cops. I never said that. I'm just here to try to bring peace out of the storm. She has very solid and very deep commitment to her religious faith. She wants this community she wants to be the voice of reason, she said, and the voice of peacefulness it sounded like during the deliberations, but there just was no way to get her to respond and be responsive to the very clear questions that were asked. So for that reason, Your Honor, we have to ask this court, in considering whether this juror could be fair and impartial when she already said this morning that she had formed and expressed an opinion that it was negative towards the defendants, but then wasn't not able to remember that she'd either said that or was no longer willing to commit to that. I don't think that this juror is appropriately qualified, and for that reason we ask you to give us a cause strike.
From the state.
Will you join in the motion?
Sorry. Thank you, Mr. Goff. From the state.
Thank you, Judge. When asked what it meant on her questionnaire, she wants to see justice done. We want to be honest because everybody should get their day in court. She qualified this. If the person did what they did and they were wrong, then they need to pay the price for it. And that was a big qualifying if. The facts, she said, not really, I don't keep up with them. I'm willing to follow the law, hold the state to its burden. She repeated beyond a reasonable doubt. The defenses, she said she would listen to them and consider them, and she said she would base her verdict solely on the evidence within these four walls. And that's what she said. She said she had no negative feelings toward the defendants, and she repeated, I would give both sides a fair and impartial trial. She indicated about the flag and the old Georgia flag. That's what we're here dealing with, facts. Even with the old Georgia flag, it is not everybody that does that. Different sides are going to present different things and listen and weigh your pros and cons and be open-minded. I believe that's the point where, Judge, you asked her, do you have a fixed opinion? And she said, I do not know what brought all of this about, so I need to hear the facts. And that's when Mr. Hogue came up. At this point in time, this juror is qualified. She understands that she needs to listen to all the facts. She appears to just want the truth to come out, and for Mr. Arbery to have a day in court, which would be the opposite of having something swept under the rug. So I think she is a juror who just felt that justice needs to prevail. Not everything is just cut and dry. You have to find out everything that happened. And she basically said to Mr. Hogue, if something happened to you, I'd want to find out, well, what happened? What was it that really happened? She also then indicated if they're guilty, that's okay, and if they're not guilty, that's okay. So at this time, she also then went on to say, I want to know what really happened. And that was her reason for wanting to be on the jury. At this time, we ask you to deny the motion to strike her for cause.
The court's denying the motion. I don't think there is any way for this court to summarize what occurred during the questioning of this particular juror, and will rely upon the record to do so. The court listened to the questions being asked both by the state and the defense, considered the demeanor and responsiveness of the juror, found her to be quite open and candid. And although parties may have not agreed with or otherwise considered her answers, the court did find her candid and is going to qualify her, again, relying upon the record. So 479 is qualified. Did I get that right? Yeah, 479. 496.
So my understanding, Judge, just for the record, is that 481, 482, 484, 485, 488, 489, and 495 had all previously been struck for cause.
Correct.
All right.
Those are all on the record.
And 496, Your Honor, the state attempted to look up the residency issue. So at this time, we're actually motioning for cause on her residency issue. We did try and look up some law and discuss with the defense whether it's residency at the time of, I guess, being sworn in as a juror, or is it residency at the time of verdict? Because the problem is, on Monday the 15th, the state anticipates we're going to be in the middle of putting up this case. So at that point in time, her intention for some time before getting this juror summons was to leave this jurisdiction. She had obviously closed on her own house, that's already been done. And so now she has purchased a new house, and that closing is going to take place on the 15th with the intention to reside in it and sleep that night at that new location out of this county on the evening of the 15th. So while the state did try and find a Superior Court rule, OCGA, or a case on this point, I could not find anything. But I believe, based on the intention for residency and where she intends to reside and has been intending to reside since before her juror summons, that she should be struck for a statutory reason.
And we did confer, although I don't agree with the state's position, I didn't see any cases on it either, or any authority. However,
The court has, the rabbit hole of residence and domicile is quite a rabbit hole, so.
yes, and I started to go down there and realized it was above my pay grade. What I think is that if chosen as a juror, she will reside in Glenn County. And even though she closes on the 15th, that closing can still go on through power of attorney or other means. She will continue to reside in Glenn County literally through the end of the trial if chosen as a juror. So there is no residency issue if she's chosen. She'll be here.
So what I hear is that, in addition to that argument, Travis McMichael then is waiving any objection to residency
For that juror, yes.
for that juror. Yeah, because again, I do think it's a gray area. So, but to be safe, the court's general approach would be to err on the side of caution. So as long as that waiver, or whether the defense acknowledges that by making such an argument that a waiver would be inherent in that argument and that that waiver exists.
That's correct, Your Honor.
Is this same for
Gregory McMichael. The same for Roddy Bryant.
The court then is going to qualify Juror 496 based upon the express waiver of all three defendants to any issue with regard to residency. We'll go ahead and qualify 496. All right, what I have then is qualified 466, 475, 479, and 496. Anybody have anything different?
That's what the state has, Judge. That's what the defense has, Your Honor.
And then the holdovers will be 501, 502, and 508. All right, what I'll do then, I'm going to call in 466, 470, let me get this to them. 466, 475, 479, 496,